Yes, sir, you are audible.
Yeah, thank you very much for this nice introduction. And at the outset, I thank ICSI IIP for allowing me to conduct this session on a very interesting topic of resolution plan, designing an effective resolution plan. And this is a crucial topic as far as IBC is concerned, or we can say that it's a backbone or the soul, whole and soul of insolvency and bankruptcy code. That is a resolution. The entire intention of IBC is to have an effective resolution. The whole idea for which IBC has been enacted is having an effective resolution. A corporate debtor, a company which has entered into some problems or trouble, should be able to survive, and any stakeholders like lenders, employees, shareholders, and several others, like vendors, should be benefited out of it. Otherwise, if any entity goes into liquidation, it's a straightaway loss for that particular entity. Today's topic mainly is designing effective resolution plan. Uh, Designing effective resolution plan, again, this is a great skill set. What I always tell to my colleagues, to CACS friends, or even my team members, that IBC, if you see, Insolvency and Bankruptcy Code has a bundle of opportunities. IBC prescribes the opportunities which are prescribed under the law. There are opportunities which are stated in the law, like typically the resolution professional, the insolvency professional, they have some or other role. But one more thing I have experienced is IBC also has opportunities which are not clearly seen, like this drafting of effective resolution plan. Now, this is totally an independent assignment, a great area for professionals, whether it may be CA, CS, CWA, to practice effectively designing a resolution plan. I am fortunate enough to be a part of 3 effective resolution plans, which I am able to prepare. And what I'll do in today's session is I'll be sharing my experiences about preparation of resolution plan. What I intend here, or my goal here, is to give away what I have as far as experience is concerned. And my plan today is to uh, enable each one of you, or those, especially those who have not dealt with, or those who are not part of resolution plan, should be able to take up the assignment, should be able to prepare the resolution plan on their own. It's a great area for practice. It's a great opportunity for professionals, good paying, and apart from that, value adding work. Of course, requires certain set of skills which certainly a professional can develop, learn over a period of time, and of course, does not involve any kind of certification as such. Like unlike secretarial audits or any other audit where we take a risk. So here it is totally application of skill set. Having said so, how I intend to proceed with today's presentation. Please allow me to share the screen. So my presentation will be a combination of PPTs. The statutory provisions I have placed in a separate file, that is relevant provisions which are applicable provisions are which are there. Then apart from that, the regulations. So I'll also present the RFRP, how RFRP looks. I'll also have a template of resolution plan, which will go through. I'll show actually a resolution plan appears. The difficulty which I faced while preparing my first resolution plan. Obviously, being a confidential document, it's not available in public domain. At least at that time, it was not there available in public domain. And every resolution plan is again different. So first resolution plan, it was very difficult for me to prepare it. I'll show you actually which checklist. Our ICSI IIP's knowledge capsule 10 is there, in which the format of resolution plan is there. That was taken as a base. And after that, based upon the cases, based upon the regulations, the latest regulations, and RFRP, information memorandum, evaluation matrix, all these factors were taken into consideration. And my first resolution plan I had done. I'll just present my screen. Yes. Are you able to see my presentation?
Yes, sir.
Yeah, thank you, ma'am. So designing an effective resolution plan. Okay, ma'am, full screen is there visible now?
Yes, sir.
Okay, thank you. So designing effective resolution plan. Disclaimer, all the views here are my personal views, and those who have already dealt with this kind of assignment, have a additional experience on this, may kindly share their inputs for the benefit of all. The idea is to understanding the effective resolution plan, and anybody having a handful of experience may share their knowledge for benefit of all. With this, we start with the presentation. Summary of presentation. Don't get boggled down by this big list. It's not very big, and I assure you that the session would be interactive, much of practical oriented rather than theory. A coverage or a bird's eye view has also been captured as regards presentation. What I wish to do is a quick refresher of IBC, the object and reasons, what IBC is, legislative structure of IBC, important definitions pertaining to resolution plan only. We are not getting into IBC. We'll be focusing our presentation to a resolution plan. Resolution plan applicable provisions. Resolution plan contents. What are the mandatory contents pursuant to CIRP regulations? That is regulation 38. Additional points to be considered in the resolution plan. That is as per my experience. Some practical difficulties are there, so it's better to have these points apart from what is stated in the law. Resolution plan process and timeline. So how the process works and what is the timeline which is available. We all know IBC is a time-bound process, and none of us in the entire whole process, all the stakeholders or those who are involved, has to strictly follow the timeline which has been prescribed it. Steps for preparation of resolution plan. So what are the steps which I followed personally for preparation of resolution plan? I'll share with you those. Role of resolution professional as regards resolution resolution plan. Resolution professional is nowhere involved in preparation or drafting or negotiation of a resolution plan. RP is totally an independent person. If he takes an assistance from any other professional, whether IP or a CA or CS, for drafting of a resolution plan. So different persons have different role. RP has a different role. Resolution applicant has a different role as regards resolution plan. Committee of creditors has a different kind of responsibility as regards resolution plan. Then implementation of resolution plan, practicalities, certain practicalities I'll be discussing, which are there today's scenario as to what forms we file and what are basically the updation of master data, filing of INC 28 and completing the annual filing on those compliances. A resolution template. I have a template. I have a format of resolution plan, which we'll go through. We'll verify it's a 70-80 pages resolution plan, which we had prepared for a small resolution process. Important judgments pertaining to resolution plan. Some 50-20 important judgments are there. And if at all question and answers are there, we can take up at the end, or you can stop me at any point of time and we can discuss the question and answers. This is a big list, appears as a big list, but this is an overall overview how I wish to cover today's presentation. IBC, like I said, a refresher of IBC related provisions, a quick refresher of statutory provisions. Provisions governing a resolution plan. So we'll be very checking or theoretical aspect of it. Those will also be quickly run through as to what is the law as on today's date, the amended provisions, what are the requirements today as regards drafting of resolution plan. That is resolution plan, its approval process, its mandatory contents. So both the IBC, section 30, 31, the provisions we'll be looking at. Process of drafting of resolution plan. We'll see what is the process of drafting of resolution plan, implementation of resolution plan, format of resolution plan, like I said, template, additional points to be covered in resolution plan, role of stakeholders and case laws. Yes. So IBC, a quick refresher of IBC. The law was prepared or drafted with a view to consolidate and amend the law relating to reorganization of insolvency resolution process, multiplicity of laws, multiplicity of jurisdiction, authoritative jurisdiction, again, lack of clarity, lack of awareness, inefficiency, not inefficiency as such, but lack of power in the then forums, as far as the law, also the laws, the BIF are also. So in order to cover up that, IBC was enacted. It prescribes a strict time-bound manner resolution process. 180 days, resolution professional becomes an Atma or a soul of a corporate debtor. Additionally, if required with the approval of committee of creditors and for special circumstances, 90 days extension is available. Overall, 270 days timeline is there. Maximization of value is the main intention. Why the quick resolution process is there? Maximization of value. Promote entrepreneurship, availability of credit. Basically, bank will be in comfort zone. And if we see the way the banks are going into the IBC nowadays, and the way the resolution plans are being implemented, it is phenomenal. Of course, there is a dark side. There are several dark side. I agree with those also. Getting adjudicate matter listed before the adjudicating authority, getting the matter heard. That is the practical difficulty. But yes, this is India, and if you imagine, if you see only Mumbai bench, there are more than 22 or 25,000 cases and only 6 benches. So can't help with that. But still, I feel overall, in my view, this IBC has changed the life of professional, and it has done a phenomenal job as regards recovery or resolution of corporate insolvency resolution process for banks as well as various private parties, that is operational creditors and lenders. Then constitution of IBBI. IBBI is doing great and fantastic job, a great monitoring over the professionals and all the pillars of the insolvency and bankruptcy code. Painless mechanism, cross-border insolvency, efforts are being taken and enabling provisions are there in the law wherein cross-border insolvency appears to be a future opportunity. Resolve India's bad debt problem. Yes, so these are intentions of IBC. Quick refresher of code. It covers insolvency of individual partnerships, LLPs, all the individual related provisions not yet notified, only corporate insolvency resolution process is notified. IBBI regulations, it governs, oversights IPs, IPAs, and information utilities. These are adjudicating authorities and agencies shall develop a code of conduct for all of us, the professionals, which need to be followed. Code of conduct process timeline of 180 days. Codeless 180 days timeline process, management of corporate debtor by RP and IRP. Prepare a resolution plan as confirmed by RP. Resolution plan to be approved by 66% of voting. Earlier it was 75. After a long back an amendment took place, it became 66% of financial creditors. Approval is required in that case, and post that an adjudicating authority approval. If resolution plan is not approved, the process goes for liquidation. We all are aware of it. Legislative structure of IBC, 255 sections and schedules. This is the way the chapters are divided. I'm going to share this presentation. Nothing much or more to discuss. There are 5 parts and each chapters. Part 2 discusses about or prescribes for section 4 to section 77, the corporate insolvency resolution process. Moving forward, the legislative structure of IBC. I'll be sharing this PPT, so you'll be having this these chapters of IBC, how the categorization. This is the structure of IBC. The adjudicating authority in case of companies and LLPs, companies and individuals, NCLT, NCLT in Supreme Court, DRT, DRAT, and Supreme Court. These are the prescribed adjudicating authority under the law. 4 important pillars, 5 important pillars under the IBC governed by IBBI. First and foremost is the IBBI, which runs the entire show. It ensures the effective implementation of IBC and all the rules and regulations through all these pillar members. Insolvency professionals, IPAs, that is all these section 25 companies or section 8 companies floated by respective institutes. Adjudicating authority, we already saw NCLT, NCLT, and information utility, that is NESL, the only NESL which provides core services right now. Now we move to, this was about a quick refresher of IBC. Important definitions under IBC will cover up. What do you mean by insolvency? I have taken a plain dictionary meaning, Oxford dictionary meaning, that state not enough to money, a state of having not enough money to pay whatever you owe. So a person is insolvent where his debts are more and assets are less. Inability to pay the debts is a state of insolvency. Bankruptcy, other is a declaration by a court. Official declaration of insolvency by a court of an individual is bankruptcy. As against that, resolution means solve or settle a dispute or a problem. So insolvency resolution is finding a solution. Solution or setting aside a problem or a dispute. Then we move to the next definition, important definition of section 525 of IBC, resolution applicant. Resolution applicant, who is this person? Or it may be individual or jointly. Who is a resolution applicant? A person comes forward and gives a resolution plan. Gives a resolution plan with a view to revive, with a view to rehabilitate. take over by whatever means are available to take over the running entity. Successful resolution plan. Now, let's see the resolution applicant definition means a person who individually or jointly. So, jointly a resolution plan can be submitted with any other person, submits a resolution plan to the resolution professional pursuant to the invitation under Clause H under of subsection of section 25, that is RP has sent an invitation expression of interest in form G or pursuant to 54K, that is in case of pre-packed insolvency process. It may be noted here that resolution is for running the corporate person as a going concern. It is not for liquidation. Resolution plan has to be prepared for effective resolution of the corporate person. It cannot be for sale of asset. It cannot be for liquidation of an entity. A resolution applicant has to give a resolution plan which will provide for revival, survival of the corporate entity as to how the revival plan is there. So that is resolution applicant, a person, individual, jointly submits a resolution plan. We move forward. Resolution plan means a plan proposed by resolution applicant for insolvency resolution process, corporate as going concern. We already discussed this as a going concern. So it should not aim for liquidation. Resolution plan aims for survival or revival of a company as a going concern. Now they have clarified that even corporate restructuring can be given effect. I have few orders of NCLT, very recent orders of 2024, which are there. If required, I can show you and definitely I'll share with you, which with respect to approval of resolution plan, and also they provide for approval of resolution plan, and also they provide for amalgamation or merger or corporate restructuring, that kind of. Yes, evaluation matrix, in my view, this is important definition. Evaluation matrix is basically parameters approved by committee of creditors as to who can. So as per law, anybody can be an resolution applicant, but committee of creditors takes into consideration the feasibility. It takes into consideration the size of the corporate debtor, the competency. Definitely a competency of resolution applicant needs to be taken into consideration, and that has been, these criteria are set. Those criteria are called as evaluation matrix. Regulation 2H of CRP regulations, evaluation matrix means such parameters to be applied and the manner of applying such parameters as approved by committee for consideration of resolution plan for its approval. So approved by committee, these are parameters as to how a resolution applicant must be, consideration of resolution applicant for its approval. Lastly, two definitions, fair value and liquidation value, very important definitions. Fair value means estimated realizable value of assets of corporate person if there is, it is exchanged between a willing buyer and willing seller at arm's length basis after proper marketing and of course without any compulsion. So a natural transaction of purchase or sale, that value particularly is a fair value. And liquidation value is the estimated value of asset of corporate person. Corporate person is liquidated on the commencement date. So on insolvency commencement date, that is on the date of admission of petition, what is the value if the company goes into liquidation? A resolution professional is cast upon a responsibility that as soon as he takes a charge, within the timeline prescribed, that is 7 days to 47 days, he has to appoint registered valuers, and he has to get a determination of value of corporate debtor as regards fair value and liquidation value. There is also a provision for him to conduct a meeting with such valuers where there is substantial difference between two values. Substantial difference, more than 25% of the difference. So in that case, there is a provision for third registered valuer to be appointed. And in that case, the two nearest value will be taken and average of it will be taken and then proceeded. So these values are very important when and kept into mind while drafting a resolution plan. That's why these are selective definitions I have collected only with a view to clarify or only with a view to discuss about the resolution plan. Now let's see the applicable provisions. Let's see the applicable provisions. For applicable provisions, I'll be presenting the sections which are pasted in the Word file. We'll go out of the presentation. Maybe I'll change the presentation. These are the applicable provisions as regards resolution plan. A person who is willing to draft a resolution plan must be well aware or well versed with the provisions, these provisions. Apart from additional skill sets, that is drafting skills or understanding the business of corporate debtor or understanding the commercial matrix or the ratio analysis, what has went wrong into the corporate debtor. All these factors are very, very important. It's like a doctor making a diagnosis where the corporate insolvency resolution process or corporate debtor went wrong and why it has come to a situation of insolvency and bankruptcy. So identifying the exact cause as to why this has happened. It may be for several reasons, right? From mismanagement, siphoning of funds, or maybe over excess capital infusion in fixed capital, mismatch of matching concept, or any other technology change, competition. So any other anything may be there. So apart from all these things, a person must be well versed with these provisions. These provisions are very, very important. 525, we already saw the definition of resolution plan. Then section 30, submission of resolution plan. A resolution applicant may. We'll go through the section quickly. Then again, approval of resolution plan. Appeal related provisions are there. Section 32 gives the reference of section 61.3. 61.3 gives three or four criteria wherein a resolution plan can be challenged. I'm also what we call as fortunate to be able to file an interlocutory application to challenge a resolution plan. Again, it was challenged in NCLAT before the NCLAT. On several grounds where basically the resolution plan, they have given 4 grounds. If it fits into it, then the resolution plan can be challenged. 74 is the punishment for contravention of moratorium or resolution plan. So that's why that is relevant. If resolution plan provisions are not complied with, 74 is a penal provision. Chapter 10 of CRP regulations is about resolution plan. The name of chapter itself is resolution plan. Relevant regulations is resolution plan, regulation 37, regulation 38, mandatory contents of resolution plan, and also regulation 39. Although I have covered, I have missed to mention over here, it is approval of resolution plan, regulation 39. So this is the legal structure, provisions, legal provisions governing the insolvency law. Let's quickly go through the provisions of section 30, 31, 32, and also the applicable provisions which are there as on today. I'll see whether I can share the entire screen.
Yes, sir.
I'll just check whether I can share the entire screen with the participants. Okay. I hope you're able to see my screen.
Yes, sir.
Yes, yes, we can see.
Maybe for this presentation, I'll turn off the camera for maybe 5-10 minutes. Yes, to start with, Section 30, submission of resolution plan. We'll touch upon the important aspects, see the theoretical aspects of submission of resolution plan. The section starts with subsection which says that resolution applicant may submit a resolution plan along with affidavit stating its eligibility under 29A. So resolution applicant willing to submit a resolution plan along with an affidavit stating that he is eligible under 29A. 29A is a very, very important provision which disqualifies or disallows a person from being a resolution applicant. He has to ensure whether he is a connected person or suffers any of the disqualification. Like they have given a list that disqualification, undischarged, insolvent, willful defaulter, any such offenses committed under the laws of foreign country. He's a promoter or group of promoter in a company where he's an NPA, the account is NPA, or he has involved into went into imprisonment for 2 years for certain offenses and 7 years for certain offenses. So that has to be ensured. He himself first of all may submit a resolution plan along with affidavit stating that he's eligible and on the basis of course, information memorandum. Then subsection 2, resolution professional shall examine. It is the duty of resolution professional to examine the resolution plan. Here it prescribes that as to payment, confirmation of payment or provision for payment of firstly CRP cost And secondly, payment to operational creditors or those financial creditors who has not voted in favor of resolution plan. Apart from that, there are several other factors which resolution professional has to examine. Like for example, whether contents of resolution plan are exactly or it covers all the mandatory contents. Secondly, whether it is conditional or not. Thirdly, whether it excludes the resolution applicant from any of responsibilities which is cast in law. So all these factors are to be taken into consideration by the resolution applicant. Then explanation to subsection 2 also says that the resolution plan or the process has to be carried out in the fair and equitable manner. Explanation 1 states that it has to be carried out in the fair and equitable manner. So it has to be on fair and equitable manner. The resolution plan has to be carried out. So explanation 2 is a transition provision. So those which resolution plans are not approved, to them also this provision of 29A, they made it applicable. Relevant is clause C. It provides for. So this is very important, very, very crucial, that resolution plan shall provide for. This is very, very important. That is provide for management of affairs of corporate person. It should provide for a resolution plan shall provide for management of resolution plan for provide for management of affairs of corporate debtor after approval of resolution plan. So how the corporate debtor will survive or revive? See, many now recently 2-3 again proposals have come wherein it is my experience. I'll share that experience. Many people have or resolution applicant have a perception in mind that resolution submission of resolution plan is buying an asset. So it's not a buying of asset. Suppose, okay, an adjacent land only is there and which is beneficial for me, or some plant and machinery is there, or some particular asset is there which is beneficial for me. It's not about buying an asset. So resolution plan must provide for. So that's a myth. That's not allowed during the CRP process. Although there are exceptions, the provisions have been made where no resolution plan has come. The resolution applicant, the resolution professional may, with the consent of committee of creditors, sell any asset. That enabling provisions are there in the regulation. But yes, when you are drafting a resolution plan or you are aiming for a resolution, management of affairs of corporate debtor as to who shall be the proposed directors, how will be the shareholding, how the company will become operational. When I show you the template, you will be able to see when we had prepared while submitting, we had given 5 years projection. I'll show you in a tabular manner. We had given projection of 5 years profitability or the financial statements, how it will appear. Secondly, implementation of supervision of resolution plan. This is very, very important. Implementation and supervision of resolution plan. As to the plan has to be workable, feasible, and it's very, very important. It should not happen that the resolution applicant backs out at future. There are instances. Also, there are judgments before NCLT, NCLAT, and also Honorable Supreme Court that resolution applicant has backed out or for on a reason that there has been an unreasonable delay. When I aimed to come forward for resolution plan or submission of resolution plan, it was a different scenario. Now almost 5 years have gone in between. So something like that may happen, but yes, resolution plan, resolution applicant certainly cannot back out once after a particular stage. The plan must provide that there is no contravention of any of provisions of law. There are cases wherein some state law, see, very wide term, all the laws under the sun. So there are certain, there were certain resolution plans which did not provide for state laws or violated the provisions of certain states laws. On that ground, the plans were rejected. Conforms to and other requirements as well specified by the board. So board has prescribed by regulations. Also very important provision is there. Suppose any additional approval is required, like approval from shareholders. Sometimes resolution plan aim for changing the name or alteration of capital, alteration of constitutional document, such things, or merger amalgamation, corporate restructuring, demerger, any kind of such kind of things. Then in that case, through the waiver clause, no fresh approval is required, or it is deemed, okay, deeming provision shall be deemed to have been given in this case. So no further shareholders approval is required. That way it can be placed or it can be mentioned in the resolution plan as well. Resolution professional shall be present. Now this is a responsibility on the resolution professional to be present at committee of creditors meeting at which the plan will be placed, he is under an obligation to place all the resolution plan. Although here it is stated that those plan which are resolution which confirm the eligibility requirement, but there is also settled law or judgment wherein it is responsibility of resolution plan, responsibility of resolution professional to place all resolution plan before the committee of creditors. Subsection 4 talks about approval of resolution plan by 66%. Committee of creditors also is cast upon a very, very important role, that is verifying the evaluation matrix, checking the evaluation matrix, what criteria are set, feasibility and viability, then priority over payment. See, in practical terms, I'll tell you what basically creditors see is how much money they are getting back, okay, and what is the timeline. Suppose a resolution plan provides for payment of or term is of 5 years. Another resolution plan, maybe the amount is bit lesser, but it provides for 2 years. So, in our case, it was like, in our case, the resolution plan was like, it was quick. It was very fast. The client had only 14 days. He said, okay, within 10 days, we'll make all the payments. So we convinced him, better you borrow some time, stay 1 month or 2 months. It is good that you pay in 10 days, but don't commit 10 days because procedural delay is there in many cases. If you miss, then it will be a penalty or the guarantee will be enforced. So obviously, committee of creditors will verify the commercial viability, the feasibility, the background or competency of resolution applicant. But it may be mentioned or it may be kept in mind that committee of creditors may incline naturally to keep in view the commercial angle of it. There is also criteria which resolution profession has to ensure, that legal compliance. Legal compliance. A better resolution plan of a resolution applicant which has suffered disqualification under 29A may be acceptable to committee of creditors, but never acceptable to the IBC provisions. So resolution professional has to ensure this. Assuming that the requirements are fulfilled, the committee of creditors may pass a resolution with a 66% of voting share, and after ensuring feasibility and viability, a resolution plan may be approved. Then it may be possible that resolution plan may take a negotiation. It may provide for change in the resolution plan. Certain additional change or terms after negotiation may take place. Few factors may not be taken into consideration, like there is a regulatory fee. You might be aware in the regulations nowadays there is a regulatory fee of 0.25% of realization value of creditors that has to be paid by the corporate applicant, the resolution applicant, to the IBBI. So provision for that fees, that is of course a part of CRP cost. But such things are there, or any kind of corrections are there, like some mandatory content has been missed, or it has, my experience is that it has happened that the resolution applicant sometimes tries to protect him and tries to put in some conditions. So it is always advisable. My personal experience is conditional resolution plan should not be there. If you see the judgments of NCLT and NCLAT, there are mixed judgments. I can share you the judgments also after this presentation. I'll be sharing with you everything, all these 15-20 judgments, along with citations, along with case laws, the original orders. So there are certain judgments from both the sides. Those are from both the sides. Some are from, yes, conditional resolution can be approved, provided that it should not have a condition of withdrawal. It should not withdraw. Secondly, there are judgments wherein conditional should not be there. Practically, my experience is resolution professional is definitely not willing to have a conditional resolution plan. Then we come to, again, further provisions are transition provision after amendment of an introduction of amendment or ordinance or amendment. Then the resolution applicant may attend the meeting. Resolution applicant is allowed to attend the meeting, and of course, he does not have a voting power. He does not have a voting right over there. And the resolution, upon fulfillment of all these conditions, upon fulfillment of all the conditions prescribed, resolution professional shall submit a resolution plan as approved by committee of creditors to the adjudicating authority. Again, there is a condition that resolution professional shall endeavor to submit a resolution plan before the adjudicating authority at least 15 days before the end of the CIRP period. So before end of CRP period, suppose 180 days is there assuming. So it should be before 165th day. At least 15 days margin has to be specified, mentioned in that. One more thing I forgot to mention, that is one-time modification. After negotiation with committee of creditors, At one instance, modification of resolution plan is allowed, 30 days time may be given. Of course, that entire thing has to be within the prescribed time limit only. Slight modification is allowed and only one-time modification is allowed in the resolution plan, which is submitted before the authority. Moving forward, we come to section 31. Section 30, we saw the submission of resolution plan. Section 31, approval of resolution plan. So it's a plain section about approval of resolution plan, that is adjudicating authority ensures that the plan meets the requirements as referred to in section 30 subsection 2, and it may approve the plan, and of course the plan is binding on all the government, state government, local authorities, employees, authorities everywhere. It is a binding force and it is enforceable on all. Adjudicating authority before passing order has to also ensure that effective implementation is there. Adjudicating authority cannot enter into the commercial wisdom of committee of creditors. It cannot advise the committee of creditors to modify the resolution plan as from commercial point of view. Of course, if there is any violation, if adjudicating authority is of view that plan contravenes any of the provisions of the law, then the plan is definitely liable to be rejected. Where adjudicating authority is satisfied that the plan does not conform with the requirement, it may reject the resolution plan. Now, subsection 4 provides for necessary approvals. 1 year's time is given to the resolution plan applicant. It is not 1 year, it is 1 year or whatever time is required by a particular authority, whichever is higher, whichever is later. So 1 year, earlier it was 1 year, now it is 1 year or time required by respective authority to obtain clearance. Also, it has held that this is a directory provision that CCI's approval is required, Competition Commission of India's approval is required before approval by committee of creditors. This thing has to be ensured by the resolution applicant. Yes, so that is 31. Section 32, like I said, these are, I hope you are able to see, I have intentionally shared the entire screen only. 32 gives a reference of 61.3 and the criteria, and again, punishment for contravention of resolution plan. Nothing as such special into it. These are contravening provisions. Any willfully committed any default or defrauding creditors, or fraudulently 29A non-eligible person has submitted the plan. In that case, any of the violations of conditions or contravention of resolution plan, the penal provisions or consequences may be applicable. To that effect, a declaration has also been taken, affidavit has also been taken from the resolution applicant that whatever data he is submitting or eligibility criteria or evaluation matrix he submitted, are true and fair. He is not disqualified under 29. When you see the resolution plan, you will ensure, or you will see that section 61, which prescribes the appeal provisions. These are the grounds on which appeal is possible. Approved resolution plan is in contravention of provisions of any law. It happens sometime. Nobody willfully contravenes the provision of law. Sometimes it happens some state law, because the concept is very, very wide. It's very, very vague, that compliance of all the applicable laws, all, whether it may be central law or state law. Many of you are not aware about state laws which are there. It may be Stamp Act, it may be electricity or local clearances, maybe entertainment tax related, or any kind of law which is there. If that contravention is there, the plan may be rejected. There has been material irregularity in exercise of powers. I'll tell you one example where we had challenged the approval of resolution plan. The plan was approved by 98% of committee of creditors, 98% of majority of resolution committee of creditors, and it was successfully submitted to the adjudicating authority. We challenged on the ground of material irregularity, stating that the resolution plan provided, for example, I'll tell you, it was a construction company, and in that case, the land was considered. It was shown that 7 acres of land is there, in which residential projects will be completed, and that will fetch money, that will generate revenue. However, it was not taken into consideration that particular land falls under the some part of land, not the same land, but in same case, two different locations the land was there. First location, it was green zone. It was green zone wherein civil construction was not allowed. Secondly, the land was part of defense area. It was in defense area. NDA area it was there. So in that case, we challenge the plan that you have made this assumption. So this is a material irregularity. I don't know how it happened, but yes, we challenge the plan on that ground. And of course, that was liable to be rejected. Date owed to operational creditor. There is a essential provision or mandatory provision. Operational creditor should get at least what they are eligible. It should not happen that, oh, winding up would have taken place or liquidation would have taken place, we would have got more money. That should not happen. So resolution professional also ensures this, that date owed to operational creditors of corporate debtor are not provided for. They are provided for, then that is okay. If not provided for, and again above liquidation value, then the plan is acceptable. Insolvency resolution process cost has been not been provided for. This is very, very important. This includes also the resolution professionals remuneration and also the costs pertaining to the resolution process, CIRP, including the interim finance and related costs. Resolution plan does not comply with the specifications as may be prescribed by the board. So these are the grounds on which a person willing to file or oppose the resolution plan, they have specifically given. If you want to oppose any plan before the authorities, then in that case, you have to ensure that the justification fits in any of these clauses. Moving forward, this is a template we'll see at end. We'll see the CRP regulations. CRP regulations, regulation 37, 38, 39. I hope all of you are with me and we are good going. If any doubt is there, any query is there, you can stop me at any point of time and we can certainly discuss. So IBBI insolvency resolution process regulations, regulation 37, 38, 39. 37 provides for resolution plan. Okay. So resolution plan shall provide the measures. Like I said, like a doctor, a diagnosis has to be made and measures for insolvency resolution process with a view to have a maximization of value, which is the ultimate goal of IBC. So maximization of value of assets has to be taken into consideration. Resolution plan may provide for it. This is an inclusive exercise. This is an inclusive exercise definition or inclusive activity. So apart from this or a combination of this is also allowed in the resolution plan. Resolution plan may provide for transfer of all or any of the assets of the corporate debtor to one or more person. So it may provide if the committee of creditors so feel that transfer of asset would be more beneficial rather than selling as a going concern or something like that, or no resolution plan is there. The resolution plan may contain the provision for sale of assets, sale of any part of assets, whether such has any security interest or not. Security interest, any charge, encumbrance, lien is created on that. Resolution plan may also provide for restructuring, that is merger, demerger, amalgamation. Practically, I will tell you, there are different practices followed by the bench. Some benches insist that if a scheme is there, scheme of merger or amalgamation is there, they prefer you file a separate application for that, a separate case number for that. Some benches entertain that in the same way the orders are passed. I'll also show you some of the NCLT orders wherein amalgamation merger has been proposed and those orders have been approved. Substantial acquisition of shares by way of merger consolidation. So instead of merger or consolidation, substantial acquisition of shares can also take place through which control can be acquired. Cancellation or delisting of securities. Many a times I have seen in case of listed companies, it is the cancel. They don't cancel, they just delist the trading. Listing is there, but trading they cancel. Then satisfaction or modification of security interest. Certainly it provides for satisfaction of security interest or closure of security interest, curing or waiving of breach of any of the date, reduction in the amount payable to creditors. Now this is what is called as haircut. How much will people get? This is called as haircut. Whatever amount is reduced to the creditors, this is an enabling provision. Extension of maturity, negotiation on interest rate, term of debt may be modified, maybe 2 years, maybe made at 5 years or something like that. Amendment to constitutional document. Sometimes it may be possible that constitutional document may provide for some restrictive clauses like shareholders agreement is there or classes of shares are there, which have no more relevance as far as corporate debtor is concerned as a going concern. So with a view to gain maximum advantage, with a view to revive the company effectively, with a view to cure what has happened bad in past, constitutional document may require amendment and resolution plan may provide for that. That will be a single window clearance. No fresh approval is required. In many of instances, you might have seen that ROC forms are submitted where attachment is only the resolution plan. Several things are given effect, and MCA forms are filled up only by attaching the resolution plan. Resolution plan. So that's why it is very, very important that resolution plan contains each and every aspect, taking into consideration the future prospects or future activities. Issuance of securities, of course, for cash, for consideration within cash, it may be equity, it may be debt instrument, it may be debentures over a period, payable to be redeemed over a period. Change in portfolio of goods and services. Sometimes it may happen that goods have become obsolete, not sellable into the market. So the new product line can be chosen. Technology use. Nowadays, artificial intelligence, cloud based operations are there. So technology used by corporate data may also be changed with a view to suit the current market requirements. Obtaining necessary approvals from central state government. That timeline we saw, the prescriptions are there. Then sale or one or more of assets to one or more successful resolution applicants, submitting such in the manner and the manner of dealing with the remaining assets. So these factors are to be dealt with in the resolution plan. Resolution plan may provide for this, and this includes, that means it may be a combination of anything or anything altogether different also, based upon the factual requirements, based upon the facts and circumstances of the case. Regulation 38, mandatory contents of resolution plan. We'll quickly go
Sandeep
through
sir,
this.
can I ask a question here?
Yes, ma'am. Please tell me.
Sir, whatever are the content of regulation 37, are there mandatory content? Like we have to mention that in resolution plan, or only the regulation 38 is mandatory?
38 is only mandatory, and 37 is basically the exercise which you can take. It is not mandatory that everything should happen. Okay.
Okay, fine.
You can
So we're not required to completely mention the regulation 37 in our resolution plan.
No. It need not.
Fine.
At least in our resolution plan, we have not mentioned that. But
Yes,
similar is true for say, regulation 38. If I'll show you the template of resolution plan, a table is inserted, and in that table we have mentioned that respective resolution and every clause, all those 13 clauses, how we have provided for. So 37 regulation need not be mentioned. It is just an enabling provision as to what kind or what activity can has taken place. So you can just give a reference that merger demerger has happened pursuant to regulation 37, or constitutional document be amended that way.
Okay. Thank you, sir. Thank you.
But 38, yes, 38, I'll show you the table, ma'am, when we go
Yes.
through the template.
So actually, we also used to give the table for 38, but we never use 37. That's why I have a query regarding 37.
Still, additionally, one wants to give, that is okay. But even I have done the same. In my resolution plan, one of the templates I'll show you. And even before this presentation also, or while preparing my resolution plan, what I did is, firstly, wait, let me show you this. So these are the cases which we are going to discuss. Okay. Are you able to see this?
Yes.
When you Google resolution plan, you find this. So this is a help given to us by ICSI IIP, and this help up to a large extent. This is a format which has been given by them, and the template, what is the coverage and everything, whether the plan suits. So this helped us up to a lot extent. And still, what is there? These are just headings. These are just headings. They have given judgments also. But again, if you look for contents, what help us more, I'll tell you, is the NCLT orders approving the resolution plan. We scanned around 100 plus orders of NCLT approving resolution plan. Fortunately, everything is online. Now see table of contents, everything this we referred to, and this was taken as a base for our resolution plan. And then we saw the orders. I'll also quickly show you one order approving resolution plan. Let's see the merger order. The rest of the orders are same only. So these orders also give us a clarity based upon these orders as to how the payments are made, or how the table which was there. Many times, not 100%, but at least 30-40%, these orders are replica of your resolution plan. Sometimes you'll agree with me. Sometimes we get a call from NCLT. They say that, sir, please give us soft copy of your petition or reply or your application. so that they should be able to, and again, bookmarking exercise have been brought in case of NCLT, so that they should be able to copy the content and paste it. So orders are pasted in that manner. Many resolution plan you will see this is again they have pasted it.
I
So in
think, sir, we
this-
can also use the Form H content as a mandatory content.
Sorry.
In Form H also the table is given in Form H
Absolutely,
compliance
absolutely.
certificate.
Correct. In Form H also the compliance.
But I have seen that their regulation 37 was not there. That's why I
Yeah,
have a doubt in
37
my
is not
mind.
there. Even so many resolution plans I have seen, 37 is not there. 37's reference is given only where a specific activity has to be done. Now see, these kind of tables, class or categories, resolution,
Yes.
equity, how much payment has been made. These tables and everything, no, we got it from NCLT orders only in our resolution plan.
Yes. And sir, in Form H also word copy in IBY website we can found all these things.
Yes,
in word
correct. On
format.
IBBI website is also a great source for all these things. Even we are expected while drafting the resolution plan, we are expected to keep a watch on IBBI website, because claims, new claims are admitted, and those are updated. So the
Yes.
day we are submitting the data, the claims are to be updated. The resolution applicant keeps on, resolution professional keeps on updating the data. Some are disputed, some error solving, some additional queries are there, some claims are rejected, some new claims, delayed claims come. So because of that, the figures keep on changing. So IBBI website is also very informative, which helps us, and past orders also.
Thank you, sir.
Yes. Moving ahead, mandatory contents of resolution plan. Of course, amount payable to creditors, operational creditors, financial creditors who have not voted against, that is not in favor. How the interest of stakeholders will be balanced as to what will happen with employees, what will happen with tax authorities. Somehow tax authorities are not happy in many cases. In many genuine cases also, recently I saw a case wherein tax liability was 4 and the income tax liability was 4.5 crore. And the amount paid to them was 4,50,000 rupees. So definitely they are not happy, but can't help. IBC is also in law, and that is for effective revival. The goal and intention, if we see, and it of course it overrides all. Once the resolution plan provides for it, all the previous liabilities extinguish. Amount payable, then how the interest of all are taken care of. Then there has to be a statement included giving details of resolution applicant, related parties who has failed, whether resolution applicant or their related parties have failed in implementing a resolution plan somewhere in past. So to that effect, a statement you will see in any resolution plan. A resolution plan also shall provide for term. A term has to be mentioned, implementation schedule, how it will be implemented, management and control. See, I've seen at many instances that they just say that 2 new directors will be appointed, or 3 or 5 new directors will be appointed. They don't mention the name and everything. In my view, it is advisable to give the full particulars. We give a table in the tabular format, the dean, the PAN, the passport number, the name of the person has to be there. Again, in my view, I don't know. As a safe practice, what we do is we also take a DIR2 form. The consent form is there. We attach it to DIR12 along with the, ideally it is not required, but still we take it. To be appointed as additional director. These monitoring agency appointed directors are additional directors, and later on new shareholders confirm their appointment. So management and control, how it will be, who will be director, how much shareholding will be there with whom. Adequate means for supervising and implementation. Of course, monitoring committee is there for supervising. Then provides for, and the requirement for monitoring committee is also prescribed in the resolution plan only as to how will be the composition. It may be one, maybe RP, the representative financial creditor, or some professional. So they may form part of a supervision or implementation or monitoring committee. Provide for a manner in which the proceeding with respect to avoidance transaction and the manner in which the money or sales proceedings. Suppose there are extortionate credit transactions, preferential transactions, undervalued or overvalued transactions have taken place, and the matter has been taken before the adjudicating authority. It is under decision, and later on it is discovered that there is some recovery out of it. Then the money will go to whom? There are judgments. Of course, resolution plan should provide for that. That should go to the financial creditors who have taken a haircut, who has reduced their amount of claim. So normally, I've seen plans wherein they prescribe that within 7 days the resolution applicant will pay this amount to the financial creditors. Such kind of provision is there. So resolution plan may provide for that as well. Address the cause of default as to why the default was happened. What may be the reason? There may be several reasons, mainly mismanagement or over employment of capital. In our case, I remember one of small cases, not very big case, but company, what they did, a big mistake they did, they brought a capital asset. Instead of leasing an office, they purchased an office of 15 crore rupees. Due to which a growing company, a good company, the funds were blocked, capital were blocked, and they started facing difficulties and eventually went into liquidation. So there comes a resolution plan who plays an important role. He may take a corrective action in this. Of course, experts' help is taken into this, but he may take corrective action, that is release of capital, raising additional working capital. So all those things happen as a resolution. So addressing the cause of default, feasibility and viability, whether this is viable, effective implementation, approvals required, and timeline for the same. So what approvals are required need to be prescribed. Resolution also has to see the capability to implement. Then monitoring committee, the prescription for monitoring committee is there. That is the composition and what are additional requirements are there. So this is about mandatory contents. Apart from that, I have a slide wherein I have mentioned 7-8 things which in my view I saw missing in the resolution plan. So those I'll tell when we move to the slide. Coming to the next regulations, that is approval of resolution plan. That is prospective resolution applicant, a final list. Now timeline also it is there on the slide. I'll show you that. So a prospective resolution applicant submit a resolution plan electronically. See, RFRP is a document. RFRP is a document which prescribes, that's a communication between the resolution applicant and the prospective resolution applicants, the provisional list and the final list. It is a communication between them, and the RFRP is a document which prescribes as to how the resolution plan has to be submitted. It's a communication from the resolution professional, RP or IRP, to the, of course, RP to the resolution applicant, proposed resolution applicant, as to how the plan should be. What are the requirements? What are the criteria are there? I also have a resolution. After this clause, we'll see the resolution RFRP document. RFRP is also a confidential document, but I'll be able to show you this document because this is available in public domain. Fortunately, I could find many RFRPs on Google. One of them I have downloaded for the benefit of all. We'll quickly run through that as well. Electronic data has to be submitted along with an affidavit, undertaking. So 5 kinds of undertakings are given. That is all the information given. Firstly, 29A, that is not disqualified. All the information is given with true. And if at all something is proved that it is not correct. So in that case, if it is not true, sorry. So if it is not true, penal action or legal action may be taken. Of course, resolution plan will also be cancelled. The resolution professional may envisage the following request for resolution plan. Resolution professional may envisage the modification, but more than once. We already discussed this. Resolution plan modification is possible. Maybe some practical query or some problem may be there, or some quick verification takes place from resolution professional, and he may suggest few provisions like we discussed 38, some clause is missing, or sometimes many times the resolution applicant is inclined, don't know why, but yes, he tries to protect himself by putting certain conditions. If those are not acceptable, or any calculation error is there, or some provision, any kind of change is there, one-time modification is allowed. Then it may provide for challenge mechanism. That is nowadays it's becoming popular, that tiebreaker, even event of how the resolution plan has to be placed. They have prescribed it, how the resolution at one time, at one going, only the resolution plan has to be placed, and in the resolution the tiebreaker formula already has to be announced well in advance. It may be by a draw system, it may be by another quick voting, or maybe written voting or ballot voting, or any other non-financial criteria may be kept, based upon which the resolution applicant may be allotted the project. Of course, in case of tie. Resolution professionals will submit to the committee all the plans which comply with the requirements. It's not like that actually. There are judgments wherein the resolution and pursuant to resolution 25, resolution professional is under an obligation to present all the plans which are there before the committee of creditors. Whether they comply with the requirements or not, that's a different story. Later on, they analyze, but he has to keep updated. There is also a mechanism wherein a resolution plan resolution professor has to be constantly in touch with committee of creditors. Of course, he acts as an agent for them, and he has to, being a creditors driven process, he has to report them to the creditors only. So each and every minute details affecting the CIRP, he has to communicate to the committee of creditors through the meetings or communication. Then preferential transaction, undervalued transaction, external transaction, we discussed this. The committee shall evaluate the resolution plans as per evaluation matrix. So this is a responsibility cast. We already saw in the section upon the committee of creditors, and vote on such resolution plans simultaneously. So voting criteria they have given, how it happens. Whatever minimum voting is required, that is 66%, whether that has happened or not. In that case, plan is not approved, maybe fresh voting process may carried out. Here, one plan is approved clearly, part B, plan B is approved, 66% is process. Here, there is a tie situation, a tiebreaker system can be followed. Any kind of situation system may be there, or maybe further negotiation, or maybe a draw system, or maybe, like I said, a non-financial criteria may be taken into consideration, maybe the experience or expertise of corporate resolution applicant. These factors may be taken into consideration, and again, a voting can take place, and the tiebreaker can be. So, by this methodology, the time is saved, and the valuation of corporate debtor is maximized. So, shall endeavor to submit the resolution plan. This we already discussed. That at least 15 days before the resolution plan to be submitted before the adjudicating authority. Adjudicating authority then forthwith a copy of order. As soon as it is approved, the copy may be circulated. Order may be circulated to the participants. No proceeding against. Now, this is again a provision. No proceedings shall be initiated against IP or IRP for any offense or defaults for prior period. A person is in charge of management and control, seeking assistance from. So he may seek assistance. Sometimes a police assistance is required to like if there is a retaliation from acquisition or takeover of a project or takeover of a company or carrying out any activity. Lastly, any person aggrieved for non-implementation of resolution plan may, of course, approach the adjudicating authority. NCLT petition may be filed under regulation. So this is about, this is all law which we discussed. Please allow me to, so this is the slide which we discussed.
Sir, I have few queries. Can I ask?
Yes, ma'am.
Regarding
Please
these
tell me. Yes, ma'am. Please tell me.
Sir, regarding regulation 38, since you have mentioned that about the management of CD, it is a mandatory content in the resolution plan. So, sir,
Yes.
it is compulsory to have the name of the directors who will take the management after the approval of resolution plan.
See,
Is
it is
it
not
compulsory
compulsory.
to have that? Okay.
It is not compulsory. I have studied 7-8 NCLT orders or few resolution plan I could get access of recently. So
Okay.
very recent resolution plan approved by adjudicating on authority on 24th of July 2024. Okay, that resolution plan does not contain the names of directors. It only mentions that 2 representatives designated by. In my view, that is not advisable.
Sir, should
In
we
my
not
view, that is
require to
advisable.
check the 29A compliance for that proposed directors? It is compulsory or not for checking of
See,
29A compliance for
Yeah, I
the
agree with
proposed
you. See, what
management?
happens, practically what happens is the person are known, the people are known. 29A compliance is checked. Normally, they are the directors of holding company only or general managers of holding that resolution applicant only. They are known. The only thing is that they don't disclose in the resolution application. There's a resolution plan, and there's no reason for that. So that's why I said, as a good practice, it is advisable to put in. What we do is we put in a table. When I'll go through template, I'll show you that we mention the dean, also the PAN, the passport number of the person.
Exactly, sir. We also do the same, but I found that in some of the resolution plan, the information is missing, as you stated that.
Absolutely, absolutely. I don't know what's the
But
reason.
then
for that,
how
but
we
that's-
can check the 29A compliance for the new management, whether they are in line with the 29A or not? Then I think name should be
Yes,
there.
yes, maybe it has to be there in resolution plan. But I said practically what happens is resolution professionally is aware. Orally they say that, sir, this director would be there, and the same director would be there as a continuing as a director in that group company. So based upon
Yes, sir.
that, maybe.
Okay,
Sir,
sir, regarding the modification, yes.
Sir, in this regard, I would like to add something.
Yes, please, sir.
In certain cases, what we do, suppose the resolution plan doesn't speaks about name of the management, then while conducting the due diligence, we separately call the name from the RA and include in our report. We call the RA, you provide the name, who is going to be your next management person, and we include in our due diligence report.
Yeah, it's a good practice, sir. Definitely.
Okay, thank
So
you.
regarding the
Sucheta.
modification part, sir, modification of the resolution plan, it is stated that it can be modified only once. So that as practically we observe that when we submit the resolution plan, there are some mandate in statutory compliance, there are deficiencies in the statutory compliance. We submit it modified plan once, and thereafter when negotiation part take place, we again submit it. So is this considered as a modification, or can we do that modify plan more than once, as it stated only once? So sir, I
Theoretically,
have that
yes.
query.
Theoretically, yes. Theoretically, only one modification is possible. But practically, what happens, I'll tell you. Practically, the RP may advise certain changes on the face of it. So while you document, it is only once. But when you carry out the exercise, of course, that is for the benefit. It's not a fraud or something. It is for the benefit of the successful resolution plan or for effective resolution plan. So practically, yes, 2-3 times or at several occasions, the modification take place. But officially, the plan is submitted to resolution professional, and it appears, or rather, it should appear that only one time modification is allowed. Several modification, it will be clear-cut violation. So one-to-one discussion can take place. Of course, there is a mechanism by which further clarifications can be taken from a resolution professional by the proposed resolution applicant. So practically, it happens that 2-3 on occasions, 2-3 discussions take place. Not officially, the draft is shared, but maybe the hard copy is shown or something like that. And 2-3 times it is done. But theoretically, it is when it is inverted and placed before the committee of creditors, one-time modification is allowed. That way it works actually. My experience is there.
Okay, fine. So regarding the price, actually, I have seen in few cases that COC not suggest the price challenge, RP not suggested the price challenge mechanism in the process. So can PRA ask the COC to adopt the price challenge mechanism? Is it is it sale or may?
It
Price
is
challenge mechanism. Is it mandatory? Like if the PRA propose to RP, then should RP is required to go for the price challenge mechanism, or it is up to the COC to adopt the price challenge mechanism or not?
See, since it's a part of resolution plan, it is a part of regulation. And if we see the judgments, recent judgments, the way the things are going, they with a view to save the time, with a view to gain maximum advantage out of it, it is advisable. They do advise that price challenge mechanism may be followed at the meetings. But yes, it is commercial wisdom, totally up to the committee of creditors. Whatever way they are comfortable, at least it's their meeting, they pass a resolution, and NCLT or adjudicating authority will not enter into that kind of commercial wisdom, the manner and everything, all those processes, as long as the legal compliance has been taken care of.
Okay, so then PRA cannot praise the COC for price challenge mechanism if it is not there in the process memorandum.
It need not be. It need not be.
Okay. Okay. So
Yeah,
one more
regarding,
question.
Mr. Kulkarni, regarding that modification which we discussed, Abhi,
Yes, sir.
what I think is that once the plan is submitted to the RP, it may be defective for any compliance, or it may be conditional. So at that time, RP can advise
Yes, sir.
the PRA to cure the defects as per the regulation. So those should not be considered modifications. Once the totally complied plan is presented before COC, at that then only one modification should be required. I think that is my understanding.
Okay, that is perfect, sir. Yes, I have experienced the same. In my case,
Because before presentation of COC, we many times two or three modifications come, because otherwise we cannot present the plan to the COC if it is defective.
totally
It is not
agree.
in compliance with the code or regulations.
Totally agree. In my case, also happened that way. That's why I insisted on that. At one point of time, we mentioned that we tried to put a condition, and we tried to inadvertently, of course, was my first resolution plan. So we tried to put some condition, and we also tried to put some a restrictive provision or protect the resolution applicant from it. So RP advised us that this kind of clauses won't be allowed. Those do not
So I
fit
think
into the four
these
corners.
are not they should not come under the definition of modifications. Once the plan is submitted to COC, after that, I think any modification only once we should be.
Correct. That is there.
Yeah. Okay. Thank you.
Yes, sir. Yes, ma'am. Anything else?
So regarding the implementation of the plan, should it require compulsory for implementing agencies to submit the progress report before the NCLT bench after it is completed? The resolution plan implementation is completed.
I think yes. The resolution plan has to provide for the constitution of implementation committee. Normally in bigger projects and financial the committee of creditors insist upon having implementation and monitoring committee, and there is a provision for it. Yes.
So is there any provision for submission of any progress report of monitoring committee to NCLT for after final implementation of the plan?
I don't think so. Yeah, I don't think so. There is any other provision.
So in some of the resolution plan, I have seen that they stated that working capital they will provide regarding the capital within 6 months or 12 months. But usually what they do, they make the upfront payment to the financial creditors. And if there is no more creditors and they provide for working capital or other capital criteria they require used to.
So you mean to say
timeline of
prepayment
2
they have
years,
done? You mean to say the prepayment they have done?
Prepayment to FCs they done. So
Okay.
now what is the practical scenario is that they don't bring that capital.
They don't bring their capital.
Time period. So practically what happened, they get the
Ma'am, sorry, I could not hear you. Your
Your
voice
in evaluation method.
cracking. Your voice is cracking, madam.
Can you please repeat, ma'am?
Sir, let me
Do one
Okay,
thing.
I
You
can
switch off your video and then.
Sir, right now.
Yes.
Sir, am I audible?
Yes, ma'am. Yes, please go on, ma'am.
So practically what happened, I have seen in few cases that sometimes the PRA has offered to the financial creditors as well as for the working capital also.
Okay. Yes, that's
But
true.
for the financial creditors, since they require their voting, so they propose them and as upfront payment.
Yes.
And for working capital, they specify certain limits like within 2 years, within 6 months, like that.
Correct.
But in that same, they not bring that amount in the CD's account. So it is a violation of the implementation of the resolution plan. So is there any provision for the summation of the progress report of the implementation plan to the NCLT?
I got your point. If that amounts
because they
to
get the weightage or in comparison to other PRAs, they get the higher votes in as per the evaluation metrics. So is there any if they don't implement or don't bring that working capital in the company, then other PRA can oppose to the adjudicating authority for non-implementation.
other PRAs, see, once the resolution plan is approved, there's no question of it. I have a case law on that. What I understand from your question is, there is an provision in the resolution plan which states that certain amount of working capital will be brought in. Upfront payment is made to financial creditors. Definitely, that's very important.
Yes.
And there is a modification in the conduct. What you state in the resolution plan, you don't conduct in that manner. That is what you're trying to say?
Yes, sir.
Yeah, I have a case law like that. When we'll be going through the case laws, there was a question whether, I think Delhi High Court case is there, a writ petition was there, wherein whether the adjudicating authority has an authority to modify the timeline for payment. Maybe taking an inference from that, it is advisable to take the concurrence of adjudicating authority. In that case, it has been held that yes, adjudicating authority can modify the timeline. Maybe many of them may not, it may not be acceptable, but it is there right now. That judgment is there. I'll show you that case. And again, it is not yet being challenged. If it is challenged, we'll get to know what the NCLT's views or the tribunal's views. But presently, we have a judgment in this presentation only, wherein they have stated that if for some reason, there is a modification in the payment terms after approval of resolution plan, the adjudicating authority can modify the timeline. Maybe 10 days, 15 days, 20 days, 30 days, 60 days, 90 days, 180 days, 120 days, 180 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 days, 1 does it require approval of COC again, or is it a modification of a resolution plan approved by COC? So they have held that adjudicating authority has this authority to make a modification of payment of amount. I'll share that judgment also with you.
So I think till now there is no provision for submission of progress report
No,
for the implementation of the plan. Whether
because
it
the
is as
responsibility
per
cast upon the
specified in the
implementation
plan or not.
committee. See, law is very clear on that. There is a committee which takes care of this. And secondly, if you remember the last regulation, if there is any problem that the plan is not implemented, in that case, adjudicating authority application can be filed by creditor.
Okay, thank you, sir.
Yes, any further questions, discussions, suggestions, queries, any suggestions additionally?
In this matter, I would like to add that if resolution plan provides for the filing of progress report, then yes, you have to file it. Otherwise, there is no provision, but at the closure of this thing, you can file a closure report after implementation, full implementation.
Great, great. Thanks, sir.
Sir, is there any specific regulation regarding the closure report?
No, no, no.
No, no. Okay. Thank you.
Okay, shall we proceed, sir? Yes, ma'am.
Yes, sir.
Yeah.
Yes,
Thank
sir.
you. I hope the screen is visible. We saw the statutory provisions which were there. We highlighted these provisions. Now, additional points in my view. Any person having an experience, any professional having an experience may add additional point to this for the benefit of all. This is based upon whatever 3-4 resolution plans we are working on right now. 3 we got approved, 1 or 2 in pipeline. Additionally, points to be considered in my view: no conditional plan we already discussed, or alternate plan. And 2 plans can be there for 2 sides. A same person can give 2 resolution plans for consideration. Of course, there should not be a condition. That can be a evaluation matrix, different evaluation matrix. And secondly, change in supplemental information binding. There is a case law on this. Once a resolution plan is approved, it's binding. Resolution application. So to that effect, a mention can be there. Resolution application cannot exclude himself from any of the responsibility, obligation, liability which is there. So by in the resolution plan, you do this only, and only after that I'll do this. If I get a license from the authority, only in that case I take over the company. That kind of things are not possible. That is not possible. Resolution applicant should not behave like a layman. There is also judgment on this, wherein resolution applicants have moved to the NCLT, adjudicating authority, or NCLT, wherein they have been stated, such kind of words have been used, that they are not lay person, laymen. They have studied it entirely, and they should have that forecast in mind with a view to revive a company. Resolution plan cannot unilaterally be changed, withdrawn by resolution applicants. There is a judgment wherein it happened that Committee of Creditors approved a resolution plan. Then the plan was slightly modified with the consent of Committee of Creditors only, not in the meeting. Not in the meeting. So Committee of Creditors approved one resolution plan. Resolution plan was modified and then directly submitted to the adjudicating authority. NCLT quashed the plan. They said that the framework of law is that commercial wisdom of Committee of Creditors is very, very important. The plan has to come in that manner only. So in this case, Committee of Creditors was bypassed. Paid up capital is considered as share capital. In many resolution plans, I have seen that issued subscribe called up paid up capital shall be cancelled, has to be mentioned. It doesn't mention about authorized capital. Authorized capital or registered capital or nominal capital is something on which the corporate debtor has already paid the fees. And why to cancel that? So in CRA form, this has to be taken into mind that the capital, authorized capital, need not be made 0. That has to be kept intact. So resolution plan should provide for bifurcation in that manner, that authorized capital will continue as it is, paid up capital will get extinguished. Approval resolution plan by
Mr. Kulkarni, I have one question.
Yes, sir.
The resolution plan, though it is not provided in any regulation, is source of funds of the PRA is mandatory to be given in with the resolution plan.
Yes, sir. Source is mandatory.
Because
And
it's
to
not
that
provided
effect, it is
anywhere
not
in the code or regulations.
Yeah. So it is not only you have to mention that source, you have to also give a proof to that effect. Suppose I am a resolution plan and I'm stating I'll be giving it through fixed deposits or mutual funds or cash and bank balance lying in my bank account. or I'll be borrowing the funds. So to that effect, maybe a sanction letter, in principle approval letter,
comfort letter, yeah.
comfort letter, a fixed deposit receipts, that has to be, that are taken by into position or consideration, that has to be attached.
Is there any case law on this? It is mandatorily required.
I
Yes, sir.
don't
I
remember
have
any.
seen.
Sorry.
Sir, I have seen many case laws in which NCLT asks the PRA to submit the affidavit for the source of funding.
Okay.
Affidavit is fine. That is mandatory requirement as per law.
No, sir.
Okay.
NCLT asks the PRA to submit the source of fund on the affidavit.
Yeah.
Okay. Thank
Sir,
you.
I'll find out some case. I'll take this as an homework for me, and I'll send an email to.
Because I'm just
FCCI.
asking because it is not provided in the code or regulations, but normally we do ask it.
I'll find out some kind of judgment in that manner. Maybe I'll find something. I'll share with along with my material.
Thank you.
Provision for allocation of recoverables. We already saw this. Extortionate transaction, extortionate credit transaction, all these transactions. The proceeds which will come, how those will be distributed. Some refund or some kind of money is there. Again, provision for under section 32A. Surprisingly, in one of the cases, a registrar of companies had sent a notice to a company which was under CIRP to the new management for the past defaults, past offenses. We replied to it definitely along with the order which is there. So 32A protects the new management. Of course, there has to be change. The person should not be involved in that particular offense. But if there is change in management, there is a clear-cut protection given that new management will not be held liable for any of the offenses which has done by the old management. And of course, the old management will not be able to claim. It is only the benefit of 32A extends only up to the corporate debtor and not the connected person therefrom. One more important thing is that any responsibility on the corporate debtor is that after takeover or after revival or taking over of the company, they are under an obligation to cooperate with the authorities for providing records of defaults. That is there. But otherwise, corporate debtor, after approval of resolution plan, the liability get extinguished. No action can be taken against the corporate debtor for past things. It is advisable to mention that clearly in the resolution plan. Details of new management and shareholders to be introduced. Names of directors along with proof. So I have seen this in many resolution plan, very recent resolution plan wherein the names of directors were not mentioned. And yes, like sir said, in the due diligence report, the name can be mentioned and 29A compliance is also mentioned, but it is advisable, better to put in a table wherein the names identify the person at first instance only, so that there is no scope for ambiguity in future. Stamp duty aspect is there. This was again in 2022 amendment. We have to ensure that a stamp duty, there is a provision, at least Maharashtra Stamp Act I have seen here in Pune, wherein there is a specific clause has been inserted. There is an amendment into the Stamp Act wherein stamp duty is required to be paid on the order of NCLT, wherein approval of resolution plan. So that also a factor has to be taken into consideration and need to be addressed in the resolution plan. Contents of resolution plan, mota moti, if you see the resolution plan, typically it appears like this. We'll go through the index and everything. Typical table of contents of resolution plan shall consist of definition, interpretation, briefs about corporate debtor, overview of corporate applicant, creditworthiness, prior experience in managing or turning, credentials as required under regulation 38. Of course, those are mandatory. Financial plan, settlement of creditors, restructuring, classification of creditors, extinguishment of claims, that is haircut, reliefs, concessions, waivers, which were there, cleanup actions, any past defaults, offenses are there, accumulated losses, correction of balance sheet, key terms for implementation of plan, terms of resolution plan and implementation schedule has to be given, the term has to be mentioned. That's a mandatory mechanism for management and control of affairs, future plans, of course. In one of the cases, it was found out, of course, they cannot do that, but somehow I don't know what was the understanding. In one of the cases, we have seen that the corporate debtor was taken over by resolution applicant, successful resolution applicant, and later on they were planning to sell out that entity. That instead of revival, so that can never be done. That's an offense, that is a contempt. So manner of supervision and implementation of plan, declaration that the plan is not in contravention of provisions of law, state laws, local state laws are normally missed out. There are judgments on this also. Statement as to how the resolution applicant has dealt with the interest of all stakeholders, how taken care about this. Then sources and identification of funds to make payments. In my experience, in our case, resolution professional also asks for supporting documents like proofs also. You give us proof as to where, show us 10 crore rupees FD, where it is. Give us a proof to that effect. So yes, that was done. Financial assumptions, presumption and business plan of the company, rationale of investment of corporate data strategies, what kind of synergy will happen, indemnify and miscellaneous items which are there. We'll go through the resolution plan also. Resolution plan process and timeline, a quick timeline and process of resolution plan, how things go, how approval takes place. We are all aware of this, but a quick refresher of this.
Sir, good afternoon to you.
Sorry.
Can I ask a question?
Yes, ma'am, please.
Yeah. See, I just want more clarity on the dissenting financial creditors. How the distribution is made, because I know under section 53, whatever is the liquidation amount minimum, that is the amount it should be provided to them and they should be paid in priority over the other secured financial creditors and all that. But what happens if they are having, more assets which are mortgaged to them, and how the distribution or the provision to the dissenting financial creditors to be made? Because under section 53, they will be basically, since they have more assets, during liquidation they will get more money. So is the resolution applicant should keep that in mind, the value of the security held by them, accordingly provide it in the resolution plan or based on the voting share in the COC, or how it is? What's your view on that?
So what I understand by your question is how they determine as to how much has to be paid to whom, right? How much to be paid to financial creditors?
No, I agree. See, what is to be paid is based on the voting share. But with respect to a dissenting financial creditor, keeping section 53 in mind and keeping the securities what he is actually holding in mind. See, secured creditor, whether he has a 1 rupee mortgage or a 1,000 rupee or 1 crore rupee, all are called a security creditors. And the voting share is mentioned in the COC is based on the claim what they have got. Correct. And the category is secured creditors. However, if a guy with a person, if a person with a very high security, if he is going to do the dissenting, seeing that if the company goes into liquidation, I am going to get more money, so let me dissent. So he is doing, but his voting share may be less, let us say 5% or 10%, but he is having a very high security value. In that case, how the payment is made, by in the resolution plan, how it is provided.
Actually, very good question. Very good question. I agree with you. Just to give an example to that effect is, suppose corporate debtor has assets in the nature of, let's say an example, vehicles, car is there and purchased 3 years back. Now the book value of the assets, if you see, or the valuation is 50 lakhs. But if you see, those were purchased at 50 lakhs. If you see today's scenario, it will hardly fetch 15 lakhs or 20 lakhs rupees. Still, these will be called as secured because there is a security created on the amount. The loan may be of 35 lakhs, 30 lakhs. It is secured by an asset. So quality of asset, definitely. And see, these criteria are there for negotiation. These are the criteria and based upon which the haircut is taken. These are the criteria which are taken into consideration. Definitely, the quality of security which is there, that also is taken into consideration by the resolution applicant while submitting.
My question is a little bit, little more I'm trying to understand here. See, secured credit, there are various judgments where it says secured creditors are one class and within them there cannot be a differentiation. And there are enough judgments for that. So even though secured creditors is one class, I, as an individual creditor, I am holding, let us say, a land and building. I am holding a land and building and other creditors are having only vehicles.
Correct.
So my security value is much more. If the company goes into liquidation, I will get more money because I am a secured creditor holding a very high security with me. So, however, in the resolution plan, my voting share is hardly 10%.
Correct.
So
Voting share is
I'm
as per your amount due.
So I am going to be a dissenting financial creditor because since I am having a high security value, I should get more money under Section 53. Because the Section 30 says very clearly whatever is the money receivable under Section 53 or the resolution plan value, whichever is higher, should be paid to me.
Correct.
So I will do a dissenting and I will say my security value is so many crores, so I need that money as a dissenting financial creditor. How do you look at this?
I agree with you, ma'am. I agree with you. That is what I said. They take these factors into consideration. Now, first of all, like you only said, that is correct and that is settled by law. That is regarding voting share. It is exactly as per the amount which is outstanding. That is okay. There is no problem in that.
Yes.
Your question is the quality of security which is there. A person having a charge over motor vehicle and another creditor who is also secured creditor having a charge over the immobile property or over a property which has appreciated value. How to differentiate that and how that is, I see, in my view, that is a negotiation with resolution applicant does. This is the homework which is, or this is commercial, commercial expertise done by or an homework done by resolution applicant based upon this. And of course, all these factors are taken into consideration and only upon that, after that, the payment matrix are decided.
Actually, she is asking that suppose that the dissenting creditor having security, liquidation value of their loan, liquidation value of their loan is higher because of the security. Then as per law, definitely he will get a minimum as per liquidation value of their security because of dissenting.
Correct.
Okay. But there is Supreme Court judgment also in certain matter that no, even dissenting creditor and all this get the equal this thing. So there is very no clarity. As per law, it is clear that he will get the liquidation value of their loan amount. I mean, as per security.
Correct.
But Supreme Court judgment is there, wherein it is, Supreme Court has discouraged the dissenting because of everybody going to dissent. Then how the resolution plan will, vote it?
Work out. Correct.
Work out. So
correct.
I think
he cannot think of himself only.
He cannot think of himself.
Unfortunately, that is there. I agree with ma'am.
So, which means under Section 53, when the RA has to provide for a dissenting financial creditor, he has to give the value of the asset, or under Section 53, the overall liquidation value, what is applicable to everyone, all the creditors.
Liquidation value, like sir has also clarified, liquidation value as per that may prima facie or morally, or it may appear an injustice to that particular person. But again, if I think only of myself, how will resolution plan work out? Unfortunately, it is like that only.
Okay.
Sir, I have a question on this, and I want to add to this problem.
Yes, please.
For
please.
clarification. Actually, the similar example we can take in this case is, assuming one financial creditor has a specific charge on a particular plant or machinery, maybe one machine. But when the valuation is done, that machine value has to be considered by the valuer, correct?
Correct.
But assume a situation which I am into, where that machinery is not at all available. Actually, there is already a case filed by that particular financial creditor that the loan which was sanctioned to this CD, they have not purchased the plant and machinery. So that means that plant or machinery is not there, correct?
Yes.
But the amount as a security is there. So he is a secured financial creditor. Now, liquidation value of the assets means the total assets or liquidation value of that particular asset or machine which is not there. So how to deal with such a situation and clarify the person, because in my view, he should not be given any payment because the machinery is not there. That particular financial creditor.
In my view, this is a clear-cut fraud transaction.
I mean, that is correct. Fraudulent transaction is when we file application for a fraudulent transaction, that is a separate application where we claim that this fraud has taken place. Now the
Sir.
financial creditor will insist that I'm a financial creditor, so I should get the amount which is
Sir, in this
available.
case, I'm sorry, in this case, he is not a secured financial creditor at all
Correct.
because the security is not purchased.
Correct. Correct. It was the responsibility of financial creditor, and banks do take a stock take. End
Yeah,
use
but-
monitoring has to be done, whether you have taken a loan for a particular purpose and used it for other purpose. Banks regularly on regular intervals keep update. They do verify physically the assets. So if that asset is not there, it is failure on the part of bank. How they can be treated as secured.
Because if he has filed an application saying that the asset is not purchased, then there is no security available for him. He is not a secured creditor at all. You see, secured creditor cannot be just based on paper, no. There should be some asset which is given as a collateral security for him for the loan given.
Definitely.
So some asset is all there. For example, normally what happens that assuming 5 crore loan is given, then maybe there are 10 machines. Maybe two machines have been
Okay.
procured, but maybe remaining 8 have not been procured.
Okay. Yeah, I agree. Then he is secured because even if there's a 1 rupee security available, he is a secured creditor.
Yeah, basically it's a fraudulent transaction, and in this case, what has happened that particular financial creditor, that is NBFC. That entity has sold its debt to some private ARC.
Okay.
See, in this case, it is advisable for that NBFC or whosoever is it to assent the resolution plan so that he will get the value equal to other. If he going to dissent, then only 1 or 2 machinery, whatever available, liquidation value of that machinery he is eligible.
So that means this is my also thinking, although I have not decided what to do in this case, but I feel that what you have now suggested, that we should separately inform that this is the value of the machine which were procured out of that the said loan, and this is the liquidation value of that machine. And that much amount he should get because he has not assented to the resolution plan actually. He has abstained actually.
Sir, in my view, just to add, in my view, this is a scenario. Now, this is a stage where he has come to a resolution plan stage.
Correct.
When the RP takes the charge, resolution professional itself, or IRP or RP itself, should have taken the corrective action in this. Maybe taking a lawyer's help, and in order to determine or file a case in that particular case, then. If this kind of fraudulent transaction has happened, of course, in order to protect the assets or property of corporate debtor, it is his responsibility. So
in that
need to
case, that
ensure what
machinery
action
will
he
not
has
be
taken in
valued.
that case.
The valuation of this machinery, how it will be done if it is not in the place, it should
And-
not reflect in the value of the company. na?
And in this, I would like to further add that for dissenting creditor, it is provide the minimum liquidation value. If above value, if the equal value, plan is providing, many a time judgment is there, court is asking no, even though he is dissenting, you have to give him, equal to other creditor. In case of the plan value is above the liquidation value, in that scenario, court asks that it is there in the statute provision that it minimum liquidation value above you can give any value to them, but so on that ground, certain cases court if we will go to the plan, he may ask that you provide the equal to as other lender, secured lender who has assented the vote.
Sir, with respect to this, in fact, one more question arises generally is that, see, unless the resolution is put for voting, we don't know whether he is going to assent or dissent. So, at the most in the resolution plan, one line can be there, it will be as per section 53 or whatever is as per the voting share. Isn't it?
Yeah, in the resolution plan, only one line is there as per section 53.
Correct. Because we don't know who is going to assent or dissent.
Exactly.
Who will be the dissenting creditor will not be known.
Exactly.
Thank you very much, sir.
Thank you. Great inputs.
Thank you. Also, in fact, one more point what I want to bring here is that, see, section 53 comes into picture only when the asset is relinquished. And hence, of course, though I was asking about the proportionate value of the assets, but section 53 talks about the relinquishment. After relinquishment of the assets, only the security creditor goes into 53. Otherwise, if he is not relinquishing the assets, 53 is not applicable to him. So when that is the case, then section 53, we even say that security creditor should be given proportionate to the voting share, because everybody should get proportionate amount, because everybody has relinquished the asset. That is other way of looking at it.
But he has got a charge. He has relinquished his right over the asset.
Yeah, because 53, that way, same way, even a guy holding a motor vehicle and a person holding a plantain machine, land and building, both of them have relinquished their security, and hence section 53 is applicable. Then once it is relinquished, they are at par.
Madam, in the CRP, relinquishment is not there. It is there in the liquidation.
Yeah.
I agree, sir. I agree. But see, for a dissenting financial creditor, what the law says under the resolution plan, either the amount as per resolution plan or the amount eligible under section 53, whichever is higher, for a dissenting financial creditor. So I am looking at it from that angle. When section 53 is applicable, we have to look at it. We have to assume that he has relinquished the security, and accordingly, what is his eligibility under section 53 for a person holding motor vehicle and for a person who is holding a land and building. Both of them are equal, and only voting share matters because both the assets have been relinquished.
That is why Supreme Court has given the judgment that
Yes.
irrespective of dissenting, you have to, you cannot claim for liquidation.
Yeah, that is one way of other way of looking at it. That's what I'm clarifying. Anyway, these are all food for thought actually, because
great discussion, brainstorming discussion.
Because there are some judgments where dissenting financial creditor goes to the court saying that my asset value is very high, accordingly I should be given more amount since I am a dissenting financial creditor. So that is why I thought I should bring that topic for discussion here. Thank you.
Very brainstorming, very interesting actually, and very logical discussion. Maybe we may have to wait for some other judgment also. Somebody goes and some new law comes into picture, because IBC every day it changes, new judgment come. So yes, great discussion.
Yes.
With your permission, shall we continue?
Yeah, please go ahead.
Yeah, thank you, ma'am. Thank you, everyone. Yes, so approval process. This is a broad process of approval. We all are aware of expression of interest, and in the regulation 40, they have given a model timeline also, which has to be followed. So the Form G, expression of interest undertaking, is given to that effect of 29A, and provisional list is then published. 5 days time is given to committee of creditors members to send an objection. Final list is there, which is released. Then information memorandum, evaluation matrix has to be provided. RFRP has to be provided. Again, the person drafting the resolution plan does his independent exercise from whatever sources, maybe Ministry of Corporate website. He downloads all the data which is there, and based upon that, studying that, the resolution plan work takes place. Has to be completed within time-bound manner. 30 days time is there. Then the plan is put to vote before committee of creditors. Committee of creditors, we already saw, is under an obligation to verify the plan. Once resolution plan is approved, steps to be taken for implementation. And in case of rejection, the matter goes for liquidation. This is one timeline. This is also timeline, the same timeline which was given in the earlier table. Then steps for preparation. In my view, again, here is a scope wherein you professional colleagues or seniors may add something into it. That is how a resolution plan should be drafted or prepared. How do I prepare a resolution plan? Normally, the assignment comes from resolution professionals only. Through the network, they identify as, okay, he's an independent person and he has an expertise or knowledge of this particular law, and where you get a chance to assist in that particular process. Are you fully convinced about resolution? Like I said before, resolution applicant, when I met the resolution applicant for the first time, it is my duty to make him aware that we are going for a resolution and not for asset sale. Many times it happens. So it is primary responsibility to ensure, rather before convincing the COC, I myself should get convinced that this is actually workable or not. I need to ensure two things. Firstly, the intention of resolution applicant is not only to come and purchase an asset. Sir, this land is there. I'll get a discount and that's why I'm here. No, sir, it doesn't happen that way. Then it happens only in liquidation. So here it is a resolution plan, making a mind, convincing them that, okay, the company has to be taken over. You have to think as to how this is beneficial, or is it really beneficial for you to take over this company and running the show? Because the whole intention of CRP process is to, so that myth should be removed from the minds that some land or some property, some plant and machinery I'll get at discount rate. No, that doesn't happen over here. Secondly, is to ensure, firstly, it's not sale of assets. Secondly, really the company is workable. In one of the instances, it had happened that actually there was nothing in the company. Technology or obsolete, clearances, and if you see, primarily it appeared that the things are not workable. Company was defunct since long time. So it has to be ensured whether this is really workable, whether this company is actually worth revival. Only after that, so the ensuring that at first step, and once set a goal that we want to have this company, then the thought process becomes clear. What we get, we compile the documents, that is, we get the information memorandum, RFRP, of course, through the resolution applicant. Resolution applicant gives us the data which is there. Now, two aspects are there. First is data pertaining to the corporate data. Maximum things are there in information memorandum, evaluation matrix, and search of MCA records, and RFRP. RFRP is also a very important document. Resolution plan drafted, of course, should not be a replica of RFRP. Should not be a mere copy paste of it. Again, independent search also has to be carried out by them. And apart from this, what is important, which resolution applicant should give us, is the commercial matrix. How much money he is going to spend, how much money fund he is going to put in, what is the timeline. These are the actual factors, how the control, implementation. So this information has to be gathered from them. What plans they have, how they wish or are willing to see this synergy going on. Whether they want to go for a merger, is that going to help? In that case, rather than taking over the company and then independently going for merger, it is advisable to put in over here, making the merger or the scheme of merger part of resolution plan. So that way the homework can be done. All these data is collected from them. Obtaining financial proposal from RA and resolution strategy, which we discussed, detailed study and drafting of resolution plan. My experience is constantly we have to monitor, like I discussed, constantly we have to monitor the updation of claims. What is the amount of claim which is being filed and admitted? Then ensuring whether resolution plan is as per IBC and CRP regulations. So commercial angle of it, legal angle of it, viability, all these factors, the coverage which is there, and proper presentation, and then signing and submission of resolution plan within prescribed time along with annexures. At this stage, we can see RFRP. Those who have seen RFRP or those who have not seen RFRP, at the end, all annexures are there. All annexures are given, the format of board resolution, the power of attorney. So all submissions, affidavits, all those formats are there which need to be given. With your permission, we'll quickly go through an RFRP which was available online. So this appears a resolution RFRP, and if you Google this is there in public domain. This is not some private data or confidential data of any client which I am sharing. This company is unknown to me. For academic purposes, I just wanted to present the RFRP document, how it appears. So this is a RFRP, request for resolution plan, and it starts with a disclaimer. I hope you are able to see the screen.
No, we are not able to see.
No. Oh, I'm so sorry. Ma'am, now we can see the screen.
Yes. Yes.
Yeah. So this is a request for resolution plan. Presenting for academic purposes. It starts with disclaimer. We'll not read in each and every clause. I'll share this as well to you, but we'll just go through, maybe in 5 minutes, we'll go through the contents as to how it is. These are all disclaimers. Basically, RFRP is a document which is a communication from a resolution professional to the proposed resolution applicants, explaining them as to the detailed methodology of this process, how the process will go, how they are expected, what should be the coverage of resolution plan. It also contains information, the financial matrix and scenario also. But mainly the intention is to request them as to, and the manner, how in sealed envelope the document should come to them, over email also, soft copy also, hard copy also. So that way as to, and what is the timeline, what is the manner in which the document has to be sent, what should be the coverage of resolution plan. So it's a communication from a resolution professional to the proposed resolution applicants. At the end, I'll also show you the annexes which are there. Now, introduction, all the information relating to the corporate debtor. Okay, this is the master details available on the, again, these are directors, they have given details of corporate insolvency resolution process, what happened when the petition got admitted, details of RP, then definitions. This is an interpretation clause, all the definitions. Then again, the maybe use of abbreviations, resolution process, how it will be. So it's an explanation given. A detailed understanding of this document is essential before drafting a resolution plan. Examination and evaluation of resolution plan, amendment to request to. When a resolution plan, RFRP document requires any amendment, fresh time has to be computed. For 30 days time has to be computed. So to that effect, a declaration or information to that effect. Right to verify the resolution plan. Right to disqualify, accept, reject resolution plan. It is the power given, authority given to the committee of creditors. So committee of creditors has a full authority as to their voting or whether they'll reject or disqualify, set the evaluation matrix in such a manner that selection process becomes simple. Certain clarifications, preparation and submission of resolution plan, the language, the resolution applicant, how each page has to be signed by each page has to be signed, and what are enclosures and attachments of documents. So this is RFRP document. I found this 2-3 days back. Personally, when I drafted my first resolution plan, I did not get how an RFRP, right? When I did my first assignment only, then I got this RFRP document. So contact details, how the resolution plan should reach. Successful resolution applicant shall maintain what are the bank guarantee, earnest money, the performance guarantee, amount of earnest money, then performance guarantee. In event of RA is failure, bidding due dates, all the due dates which are there, terms of participation, clearly understanding as to whether I'm eligible as a resolution applicant or not. Mandatory contents of resolution plan, they have just given a reference of 37 here. In this thing, actually it has to be 38. Other essential requirements, 29A, very seriously viewed. Then affidavit, resource, confidentiality, of course. Resolution plan preparation cost, applicable laws, preparation of evaluation process, resolution plan for evaluation process. Then steps are there. This is essential. Submission of receipt of resolution plan, examination, how the process will go, steps. These are the steps. Execution of definitive agreement. Miscellaneous provisions about cancellation, corrupt practices, fraudulent practices, statutory dues, non-compliance, and conditions subsequent. Now, list of appendix. Here the resolution plan ends, and this is the list of appendix. We'll not read or go through because we have to cover important case laws on the subject. So these are all enclosures. RFRP is a document. I have to just prepare these annexes, and then along with these annexes, I have to submit a resolution plan on stamp paper duly notarized. So this is a resolution, a request for resolution plan. Moving forward, we are on PPT. You are able to see the PPT now again?
Yes.
Okay. Role of resolution. Now, 3 stakeholders are there. Quickly, their role, we'll discuss role of resolution professional as regards a resolution plan. Of course, you have to monitor. He's not adjudicatory, but administrative function. He has to verify. He is responsible to verify the contents, manner dealt with, commercial viability, everything he has to verify, providing for data to RAs. He's under an obligation, responsibility to provide the data, verify resolution plans received, whether it as prescribed, carry out the process in fair and transparent manner with a view to get the maximum value. So that is a role as regards resolution. Professional RP gets the resolution plan prepared, and his viewpoint is scrutinizing or verifying that resolution plan. Role of applicant as regards resolution plan, of course, provide for measures of necessary. I have to ensure that I fit into evaluation matrix, exactly the requirement have been fulfilled. Again, maximization of value of asset, acquiring the corporate data as going concern, satisfaction or modification of security interest may be provided for. He has a right to receive information or data of CD in the CRP process because he is drafting the resolution plan. Role of COC as regards resolution plan. COC also, I think we discussed in the initial discussions only, commercial wisdom, we evaluate 66% of voting, feasibility and viability to be verified, ensuring whether the resolution plan has to be as per evaluation matrix, feasibility and viability, manner of distribution of funds amongst various classes of creditors, that has to be taken into consideration by COC. Implementation of resolution plan. Now this is crucial and a topic again where 2-3 hours session, different session can be taken on implementation, but I quickly touch upon certain practical points. There are certain cases where I'm not involved in CIRP, I'm not involved in any of the processes, but some of my client gets the resolution plan, becomes a resolution applicant, and we get a job of implementing the. Now again, this is a role of a company secretary many times, that executing the order or ensuring the monitoring of resolution process, helping them into it. Like I said in my initial discussion or opening only, that IBC prescribes what are the rights or what are the advantage or benefits or opportunities available for professionals. This is also one of the hidden benefit which is or scope of or area of practice which is available for a person implementing effective resolution plan. Very less professionals have knowledge about it. So advising on effective implementation of resolution plan is also an assignment wherein valuing role can be played. So implementation of resolution plan, immediate steps, what are required as soon as the resolution plan is approved. As soon as the resolution plan is approved, firstly constitute monitoring committee as per resolution plan, holding the meeting of monitoring committee, and new directors to be appointed. Like I said, those are appointed as additional directors, old directors to be vacated. In that case, no fresh resignation letter or anything is required since your resolution plan provides for that. So only resolution plan is attached to the file. File. New directors also. My personal advice is better to take a consent and DR2 form because that's a company law compliance. And all the requisite attachments, and then appoint the directors. File all the documents with ROC, mainly DR2 regarding the change. There may be 2 forms. Appointment form is then, and then cessation form. Allot fresh shares, or raise issue of debentures. Monitoring committee or agency may see the implementation of the plan. Any other modification of capital structure, we already discussed this. Authorized capital shall remain intact. Paid up issue to subscribe capital shall be cancelled. Many times the plan is like that only. Equity capital is cancelled, and then new share allotment takes place in that case. So custodian control as per resolution plan. Then lenders will issue no due certificate and charges will be closed. Sarsai will be updated. CBIL will be updated. If in the resolution plan, suppose the debt amount is reduced, it was 3,000 crores, now it is 1,000 crores. In that case, it is the responsibility based upon the resolution plan, the data may be or CBIL records or Sarsai records or ROC records may be updated. Wherever required, modification, or wherever required, satisfaction of charge take place. These are some of
signs
the
these ROC forms.
Sorry?
Whose responsibility is to sign these ROC forms?
Whose responsibility is to file this ROC forms?
File and sign this one.
I have seen this. The resolution applicant and his teams takes care of it. Better to provide in the resolution plan only. So new management is more keen. The work was there, their company secretary.
First, this thing change in director is being filed by the chairman of the monitoring committee, and they introduce the other director, and thereafter other director taking care of the same.
Okay, it is the liquidator signature which is attached in the form.
RP signature.
Yeah,
Monitoring committee chairman. Yeah.
yeah. Monetary committee chairman, RP's DAC is there who files the form. But it is the successful resolution applicant normally takes the charge and he ensures this compliance because of course it is in his interest now. He had taken over the company and he has to run that now.
Is limited. It is up to RP's role is limited up to introduction of the new director.
Correct.
And
Yes,
thereafter,
sir.
entire work is of RA.
Yes, sir. Yes,
Sir,
thanks
one
for adding, sir.
one question here. See, you are saying your heading says immediate steps on the approval of resolution plan. And below that, you are saying lenders will issue a no due certificate, vacate the charge or modify the charge with ROC. See, unless the resolution plan is fully implemented, lenders will not give no due certificate or vacate the charge.
Now it depends upon the facts. If they are getting a haircut or upfront payment is made, of course, I agree with you. Satisfaction will take place only after payment is made to them.
Yeah. Also, I'm looking at it from the angle of, see, the resolution applicant might have paid the upfront payment or 1 or 2 installments, but till the last installment is paid, we don't know whether it is going to be successfully implemented or not. When that is the case, the no due certificate can be given only at the end. Creditors will not give no due certificate in between.
No due certificate only in case where the satisfaction has taken place.
Correct. And vacating the charge also only at the end.
Yeah. Removing the charge is not possible in other cases. Of course. If the settlement has taken place or a modification also in cases where they have taken an haircut. Earlier, like I said, 3,000 crores, 4,000 crores loan was there. It has come through resolution plan. The limit has come. They have taken a haircut and agreed for 1,000 crores now. So obviously modification will take place. And yes, these are immediate steps, but this take time practically.
But at the same time, whether the modification of charge, whether that is required, because instead of 4,000, it has become 1,000. I agree. But should they modify the charge? Because finally, if the resolution plan says that creditors will be fully paid, if that is the resolution, then where is the question of modification of the charge? Still, the payment is made and then charge is vacated. I'm just doing a loud thing.
No, but the amount of charge is modified. Suppose the earlier limit was 4,000 crores. They have taken a haircut and now it has become 1,000 crore. It has been agreed to pay them 1,000 crore. So in CIBIL records, in ROC records, it will appear that the entire amount of charge, which was there earlier.
Okay.
So I need to modify that.
Okay. So modification takes place. Not
in my view, yes. And we did this.
See, no modification. It will be completely satisfied. There will be no charge remain in the company. Single penny, even though haircut is there, it will be completely satisfied.
So that is at the end. At the end.
At the end, correct. At the end.
But during the process, what he is saying that during the pendency of the resolution plan implementation or during the course of the implementation, first step is modify the charge and then next step will be to vacate the full charge.
The modified charge will only come into picture when it resolution plan provides so. Otherwise, what happens? The lender clearly mentioned in the resolution plan that he will give NOC only after full payment. So, even for modification, you require the consent of the lender. Without lender's consent, you cannot modify the charge.
Correct.
So, until unless resolution plan provides so, modification cannot be done.
Certainly, it should provide, and it provides.
It should provide, and it basically typically happens when there are 2-3 units, and the resolution plan provides that after certain payment, this charge on this unit will be released, or something like that. So only that case modification and satisfaction on charge on particular that happens if resolution plan provides so.
Hell lot of time it takes place, sir. We have experienced this. We have been experienced in this in case of implementation. Charges matter, especially getting the digital signature of banks, getting NOCs. Some banks have been closed long back, merged. All these practical difficulties are there.
Based on this, what comes to my mind is one more thing. Just now, sir was saying that if he has 2-3 plants, So with respect to that, is there any experience of several resolution plans, but I mean 2-3 resolution plans with respect to 2-3 assets instead of one resolution plan on the CD? Of course, in the case of real estate category, project-wise CIRP is admitted for each project, and the resolution on project
I am
takes
aware
place,
about that judgment
which
only.
I have handled it. However, in a CD, let us say it's a manufacturing company having plant in 3 different locations and maybe 3 different products, and hence there are 3 resolution plans approved, one for each plant, and then it is submitted to adjudicating authority. Is there any experience on that?
No, I am aware about only real estate matters. A project-wise resolution plan can be given, not otherwise. Otherwise, I have seen cases wherein the entire undertaking has been taken as such.
Because the regulation now provides for that. If the resolution on the entire CD is not happening, then the asset-wise resolution and the creditors can decide on how to deal with the rest of the assets. That is how the regulation has been modified recently.
Okay.
So that's why. Anyway, I think one should look at this option also.
Again, this is a great input actually. And this is also a part of negotiation between the resolution applicant and the committee of creditors again. Convincing them also then.
Actually, before this regulation comes into place, it was previously also happened in forms of 2-3 buyer, those who particular unit they club one and submit the resolution plan with demerger. This unit will be demerged with this unit will be demerged with that, and jointly it used to file and it is approved. But now since the regulation has come, so let's I mean how the since recent resolution this regulation is there, so let us see how it works.
Yes. Okay. One more thing is that nowadays, if you see the scenario, INC 28 can be filed. They have modified the form. Status of the company is under CIRP. When we file the INC 28, it becomes active, and then even DRA 12 can be filed. And regarding filings through GNL 2, the annual filing AOC for MGT7 are to be filed as attachment to form GNL 1. Our experiences. Annual filing obviously doesn't get updated because you're not filing AOC for MGT7. So it doesn't get updated in the master data, but that can be updated through form CRF now. So updating the data, they have introduced a form CRF through which the capital structure, it is not INC 28 through which the alteration takes place on master data. It is form CRF through which capital structure and the contents on master data are amended and updated. So that form as well needs to be filed with the register of companies. That forms part of implementation schedule. There are a number of difficulties in one of the cases, especially SEBI. Again, SEBI and implementation, like I said, implementation itself is a separate topic. Need to have a separate session of 3 hours. But what we are facing a difficulty is, for some reasons, it is a listed company. Now, the company was a defaulter, and no person is willing to act as an independent director. No person in India will act as an independent director in that. In that phase, we are facing difficulties getting notices from ROC that you being a listed company, but you're not complying with the provisions of independent directors requirement, or the status of the company appears as active non-compliant, even though we have done the submissions. So it is these are all practical difficulties because it is not active non-compliant. We are not able to change the address. We are not able to submit the allotment related forms. These things are there. These are all very, very practical difficulties. Implementation is a long process and many times a headache. Issues with respect to Companies Act, some of the issues we saw, issues pertaining to tax liabilities under income tax, sectoral regulations, issue with respect to past offenses. Sometimes authorities keep on sending notices, and of course we reply along with a resolution plan. The approved NCLT order we keep on sending to them, and that's an issue with implementation. There are various compliances which need to be taken care of. We already saw this. Any approval within 1 year, explanation under section 30, shareholders are required under Companies Act. Okay, then available options, furtherance of adjudicating authority. Change of status of company from CIRP to active. We already discussed this. Reconstitution of board, reconstitution of base of corporate debtor, filing of AOC for MGT 7 through GNL 1. Practical difficulty is they take on record, but they don't update the master data. CRF form serves the purpose. This was not there 1 or 2 years back. The form is introduced recently. So for a long period, we faced this problem. The filing was not showing updated. There was no mechanism into this. Yes. Now resolution plan template. Please allow me to go through the resolution plan template which is there. We'll quickly run through that in very less time. And I wish to cover is the cases. The case laws or judgments are there. Now important judgments. Firstly, we'll go through the template of a resolution plan and then important judgments under the resolution plan. After that, we can discuss the questions if any, or we can conclude. Number of cases are.
Sir, I would request better first to discuss the case law.
Okay, great. That can be done, sir. That can be done. Yeah, somehow at my end the voice is cracking. I'll turn off the camera. Now good suggestion by sir. We'll discuss the cases one by one. I have arranged these cases. I'll be sharing these cases with you, of course. I'll again share the entire screen. And yes, important cases. These are only relating to the resolution plan. Resolution plan related cases are there. Approximately, I think 19-20 cases are there, which we can discuss. Some of them are recent. Many of them are recent only. Yeah, so first cases, Deccan Value Investors LP and others. RP cannot withdraw or modify the plan. The question was whether resolution plan can be modified. Resolution plan cannot be. So unilaterally doesn't permit the modification or withdrawal of plan. Pointing out ambiguities at later stage. Like I said, discussed a while ago that it becomes difficult sometimes that at later stage, at the stage of implementation, or maybe because of delay or for some reason, resolution applicant is willing to back out. So pointing out ambiguities or lack of specific details of data post acceptance of resolution plan by the committee of creditors should be rejected except with ingress, bad or shocking exercise or fraudulent or concealment is there, then in that case it is okay. Otherwise not allowed or permitted to resolution applicant to unilaterally amend or modify or withdraw. Withdrawal is not possible. That is what this judgment says. It's a Supreme Court judgment, 6th March 2024. This is a judgment. So I made a summary of these case laws. It doesn't allow or permit the unilaterally the withdrawal by the resolution applicant. Information memorandum is not likely to be tested. See, here I said, if you remember, resolution plans are not prepared and submitted by lay persons. So it's not layman. They are not laymen. They are expected to do the full homework, study the implication, the information memorandum. All the data was properly provided to them. Later on, pointing out certain things and denying is not at all acceptable. This is case law number 1. I'll be sharing this sheet. I'll also share the judgments. If you want the full judgments, I've downloaded over here. Case laws. All these cases are there. IBC Singapore Private Limited versus Committee of Creditors. Again, this is a landmark judgment, and 2 questions were raised. Is approved resolution plan a statutory contract, and can a resolution plan be withdrawn? The answer to this is yes. It's although it is binding strictly, but it doesn't have a typical nature of contract. It is not a contract. What Supreme Court held in this case, it's not a contract. Resolution plan, even prior to approval of adjudicating authority inter se COC successful resolution, the resolution plan cannot be constituted purely as a contract. It's not a contract. It's the nature has only binding nature of it, but it is not a contract. So Supreme Court addressed that whether resolution applicant is entitled to withdraw or modify. No. Once the resolution plan there is only one provision, 12A, and there is no other provision under the law which allows withdrawal of the proceedings. And at this stage where committee of creditors has approved the resolution plan, there is no methodology, no mechanism. Supreme Court pointed out pertaining to, and then withdrawal was not permitted. You cannot do this withdrawal. So that is IBC Singapore case. I also have one case, I think case number 6 and 7, wherein contradictory views there. One view was given by NCLT Delhi bench, and the decision was quashed by NCLT. Now, another case law is Greater Noida Industrial Development Corporation case. Format of claim is not in a prescribed format. It's not prescribed format. The form which is given, we are aware of form B, C, CA, D, and E forms in CIRP process, which are claim forms required to be filed. And in this case, what had happened? Claim form was not there. Sometimes OC submitting the claim as FC. So what was held in this is, it is not the format which is there. There are also enclosures which a resolution professional need to take into consideration. Once the claim is submitted with proof, it cannot be looked merely because it was in different form. So that cannot be, that cannot be taken into picture. Actually, I have faced this kind of situation, not in case of CRP, but in case of voluntary liquidation. In case of voluntary winding up, ideally the liability has to be nil. I was given a charge and was appointed as a liquidator, voluntary liquidator in one case, and where suddenly after 2 to 3 months, an application was filed by a lady stating that my registered office address was used as a my premises was used as a registered office address. She was a ex-director's wife, a person who has resigned as a director, his wife. So that way she was related. They were in good terms when the registered office was provided. 2 years term was there, they got terminated, and later on she sent a demand notice, not in a prescribed format, of course. Only email was sent. That too, it was sent to promoters, not to me. But there I took a view that format is not important. I have to take into consideration the supporting documents. Of course, the claim was rejected for several reasons into it. But yes, at that time, I do entertain the claim, allowed her to file the claim. And although format was, so the intention is form of claim is just directory. Here, Supreme Court has directed that the form is just a directory. It is not mandatory. So even if there is a mistake, resolution professional should take into consideration the supporting documents or proof which are attached. Next case.
Sir, one question with respect to this. See, instead of form C, somebody submits form B, or instead of form B, form C is fine. But without any claim form, somebody is sending an email with, say, attachments. First of all, we should tell them that unless you submit a claim form in the prescribed form, it cannot be considered for processing at all.
Correct.
Isn't it?
Yes,
so the claim form is mandatory. Claim form is mandatory. Which claim form? Instead of sometimes during liquidation, they submit CIRP claim form, or during CIRP liquidation claim form.
Correct.
But there is a form which is provided as per statute. It is given already. Only thing is form is different.
Yes.
But without form, if somebody comes, I don't accept such claims at all. I say that you have not submitted a claim form to me. The matter is there. That's how I look at it.
No. But there is an exception to this rule, the PF matter. If PF people will even write you in a letter, you have to admit, because the PF is fall under this section liquidation estate. It is not part of liquidation estate. So there is a judgment and there is a IBC action also.
But even with respect to PF, in fact, that's what they said. We need not file a form. But I said anybody claiming under section 53, there should be a claim submitted to the liquidator. And hence form is, that is why forms are made mandatory.
But the PF amount is not part of liquidation estate. No, it is beyond. So they claim only those who file the claim who fall under this liquidation sort of.
But even then, sir, see, as a liquidator, we are responsible. We have to submit, distribute the money to the persons who have submitted the claims. But what is wrong in the PF department filing a claim? What is wrong?
IBBI, I have come to know that IBBI has issued so-called notice against one IP who has, told the PF department, you submit in the form and he has not admitted his claim. then a show cause notice has been issued. So there is a judgment or something is there. So in the PF matter, please remain precaution.
But I really don't know. See, if it is a CIRP, pending CIRP, no claim form is submitted because it comes from the resolution professional. And then liquidation expenses, it is arising out of my own action as a liquidator. Except these
For-
two, all other things should
For,
be through
for,
a claim.
for PF matter, for further precaution, you may approach to the NCLT, sir. They have filed this. Kindly either direct him to file in the form or allow us to admit the, I mean, for civil side, you can do it.
Because in the case of PF matter, I wrote to them saying that unless you submit it in the particular form, I will not be able to do. Finally, they came back and they submitted claim form. It happened with PF
Yeah.
department itself.
In my other cases also, I mean, I will not admit it, and they have approached to the NCLT, and NCLT also directed him to file in the prescribed form. But
Correct,
in the other
correct.
in the other matter, what I seen, I mean, when IP has received a so-called notice from the IBBI in this matter, when he is not admitted, they approach to the IBBI, and some judgment or something is there. That I mean, there is judgment also now in favor of this PF department. Supreme Court judgments most probably is there. That
And
they
one solution to this is we do have, as a liquidator or as an RP, we do have a timeline prescribed that suppose a claim comes, it is not up to the mark, some flaws are there, we may revert and give them time to refile it. Like you only rightly said that, okay, correct it, give it in prescribed form and we'll admit it. But point here is merely everything is there. Suppose tax invoice are there, ledger balance confirmations are there, or suppose balance sheets are there. There is a clear-cut evidence supporting it, and only because the form is not there. In that case, court will always take a view that okay, form is just a method. And now clearly in this case also Supreme Court has stated. So rejecting merely because it is not in form C, form D, form B, that is like tricky situation for us. So we should not ignore that. Just to add one more fact, in my case, I had additional grounds for rejection, not only form. In that case, third point I had mentioned that your claim is not as prescribed under IBC. I did not say that it is not in a prescribed form. I did not say it is not within the prescribed time. I just said it is not as per IBC. And before that, I had 2 points for rejection. Firstly, the audited financial statements for last 6 years was given to me. No claim was there. No rent claim was there. No provision was there. Nil assets liabilities. CA audited balance sheet was given. And again, she had a rent agreement which she had attached in support of email. There had a termination clause. So 2 years after 2 years, termination was there. Auto renewal did not happen, and it was clearly stated that it cannot be automatically removed. The only problem was company did not change its address. It was inactive. It did not change the address. That's why it gave her a ground to raise this point. But there was no provision. There was no money in the company. We had to reject in that case. So I do consider that. I advised her to submit it in the prescribed form and then rejected it. So we do have an option to ask them to submit in the correct form. Shall we proceed?
Yes, please. Only thing is my point is that in the case of voluntary liquidation, anyway, the directors are giving a declaration that, any claim arises in future, they are responsible for it. So even if it is not admitted during the course and it is dissolved, he is still responsible. Directors
100%.
are still responsible.
100%. They are responsible. And I do, again, one more point I'll tell you in that. I did advise them that, boss, whether that is genuine claim or not, your voluntary liquidation is at toss. So if they object there, your company is not going to get voluntary wound up. So better go meet and get it settled. That is what advice which I gave. To which, yes, they worked out something like that. And again, they were worried that it will become a Pandora's box. That again, she may ask for her director's remuneration, husband's director's remuneration, because he was a director as well. So they took a view that let the court direct and we will pay that. That's not an issue. But yes, in the declaration, they have given the responsibility that they are fully in charge or they are liable to pay the dues, if at all, which comes into future.
Sure. Yeah.
So
Thank
yes,
you very
Supreme
much.
Court judgment on that. Moving to next case, case number 4, RPS infrastructure case. Here again, the question was, can a claim be filed beyond a stage belated claim after approval of resolution plan? Law is settled on this. Supreme Court judgment again on this. What had happened basically in this case, there was an arbitration case going on. And arbitration case was going on, but they assumed that resolution professional is aware of this arbitration case and he should consider the claim direct only, and they did not file the claim. RP rejected the claim as 90 days from the date of commencement date was passed. Delay of 287 days took place. Arbitral award of 3 crore rupees was there, 3 crore rupees. And this was rejected. Supreme Court did not allow this. Filing of belated claim after approval of resolution plan cannot be done. CRP cannot, see, at the end they mentioned that CRT cannot become endless process. It should not become endless process. So once a resolution plan is approved, all the past liabilities get extinguished. That is what this judgment says. Moving to another case, judgment number 5. This is again Supreme Court judgment. M.K. Rajagopalan versus Periswamy Palani Gundar. COC was passed. This case I discussed while explaining. Section 164 disqualification of a director was there. What happened is such resolution plan cannot be approved where COC was. Here it happened that resolution plan was approved by committee of creditors. Later on, some modification took place, and of course with the consent of committee of creditors in this case. But they merely discussed it. It was not placed before the committee of creditors. Directly such plan, after making certain modifications, this form was filed with the claim taken to adjudicating authority. Then the approval of resolution plan was challenged. NCLT said, or Supreme Court said, that this resolution plan should come through the committee of creditors only. It was a mistake which was done in this particular case. So they bypassed the COC. This is not possible. This cannot be done. Without bypassing the COC, the resolution plan cannot be submitted to the adjudicating authority directly. The approval of resolution plan faced the challenge before the NCLT. Now, this was a judgment we were talking about, section 6, point number 6 and point number 7. This is a judgment regarding disqualification of director, especially those are company secretaries or chartered accountants who are aware about company law compliance or aware about disqualification of director. In 2017, ministry straight away released a list of disqualified directors. Several lakhs of directors were disqualified. People then moved to file a writ petition. In many cases, many high courts passed an order for quashing the decision of disqualification. Practically, there's a different story again that it did not get implemented because they kept the directors disqualified. In this case, what happened? His resolution applicant is not eligible to submit a resolution plan. He's disqualified. So it was held that he's disqualified. Even if the High Court has quashed it, it was later on. So on the date when the resolution plan was submitted, he was hit by section 29A, disqualified to act as a director. And what was held is the duty of IRP is not limited only to obtain the undertaking of from a resolution professional. It's not only the undertaking on which I can rely. I have to do my homework. So ROC list was quashed on 29th of September 21. This list was quashed. But in spite of that, NCLT held that director was disqualified at the time of submission of resolution plan. So this rejects the plan. It was rejected. Reverse view was taken. This was filed as an appeal over here. So this was Delhi bench, and the decision was reversed by NCLT here. And exactly opposite view is taken. The resolution plan submitted by resolution applicant during disqualification for a director by ROC cannot be rejected by when High Court has quashed the disqualification. When the list was published, ROC terms, and again in this case his dean was active. These all submissions were made in this case. So in 6th number, it was said that he was disqualified. Here, you cannot ignore the quashing of High Court. So Honorable NCLT entertained the resolution plan. This was exactly opposite decision. Next case, Deepak already saw. World for exports. So this was regarding waiver resolution plan submitted by resolution applicant during disqualification. No, sorry. Resolution plan having been approved. It is always open for SRA successful resolution applicant to make appropriate application before statutory authority for grant of relief. See, any relief is there, any approval, the section or regulations are clear. That is what the NCLT, Honorable NCLT said in this case. Is suppose any clearances, approvals are required within 1 year or whatever time is prescribed under that law, whichever is later, the approval has to be obtained. Secondly, any liability cannot be avoided through waivers. It goes without saying that all past liabilities which are not dealt with resolution plan stands extinguished. So all past liabilities are extinguished. Ganesham Mishra's case. Similarly, current liabilities cannot be waived. Current liabilities cannot be avoided, and any clearances that resolution applicant can obtain later on. It is just direction given in line with the regulations in this case. Now, this celebrated case, landmark case, Ganesham Mishra and Sons versus Edelweiss. After approval of resolution plan, old dues extinguished. That is what does, whether after approval of resolution plan, adjudicating authority of creditor, including government dues. So government is not again something which is different, which is treated in this. They do take backseat, and again, even if it is government claim, then it is stated that the claims as provided in the resolution plan shall stand frozen, and it will be binding on the corporate debtor, its employees, members, creditors, including government and state government. So although the government and state government has been added by way of amendment, it is still that because they have mentioned such other person or any other person, any other stakeholder. So stakeholders, government was definitely a stakeholder. So it's a clear-cut principle established that once a resolution plan is approved, all past claims get extinguished. Once a plan is duly approved, claims provided shall be frozen, shall stand frozen, and the plan is binding. So even income tax or government authorities cannot also initiate investigation, inspection, or carry out or raise new liability for the past events. This is again an interesting case. OCL Iron and Steel Limited versus Union of India, Delhi High Court's case, wherein because of past dues, prior period dues, prior to CIRP process, resolution plan was approved. A clean, what we call as a clean slate was made, and a new corporate debtor came into existence in carrying on business, and a tender was submitted, but the tender was rejected. So due to prior dues, corporate debtor was not allowed to participate in the tendering. Past dues in resolution plan are extinguished. That's why there is no relevance that should not be taken into consideration, and they were allowed to participate in the tendering and auction process in this case. This is again July 2024 judgment. Now, Rainbow Paper's most controversial case, and along with Rainbow Paper, I have also intentionally taken this case of Pachim Chal Vidyut. Now, this is an exactly opposite case again. 11-12 are opposite view, wherein they stated that Rainbow case, most controversial case. After this, government authorities started taking a view that we are secured creditors, and later on it was clarified that it is not so. In this case, it was held later on that Section 53 was totally not taken into consideration. First Rainbow case, here lot has been said in this case, a long judgment wherein it Supreme Court held that a plan which provides a plan which completely ignores government dues, a plan which provides for non-payment of government dues, how that can be an effective resolution plan. These kind of questions were asked. Again, they should be treated as secured. Their claim was there, and all those things were there, and this kind of judgment was passed, and which created a controversy. A security interest was created in that case, and they were allowed as a secured creditor in this particular case. If the resolution plan ignores the statutory demands payable to state government or legal authority, the adjudicating authority is bound to reject the resolution plan. This is what a view was taken earlier. Pashchimanchal Vidyut Vitaran Nigam Limited versus Raman Ispat. This decision was reversed. Not all dues owed under statute are treated as government dues under 53. Rainbow paper judgment did not notice the waterfall mechanism. So here it was again Supreme Court took another view wherein the matter was set aside, clarified. Otherwise, it was a randomly government officers treating that we are secured creditors. That judgment put us into the shoes of secured creditors.
Excuse
Next
me,
case.
but still rainbow judgment is in force, because later on what happened, the rainbow judgment after this Vidyut Nigam, rainbow judgment again put on review, and review was rejected. So I mean still rainbow judgment is in very much place, and we have to no choice but to follow that.
So which judgment was put for review?
Rainbow.
And that was rejected.
And that was rejected.
But sir, this judgment is passed later on now.
No. Later on passed Vidyut Nigam. Again the rainbow judgment has went to review, na?
Yeah.
Review was later on this after this Vidyut Nigam.
Okay. So thanks for this input then.
And then now since the amendment is there, on the place, but when it is approved only, then
Yes.
this judgment will.
Yes. Next case, PKH Ventures Limited versus Monitoring Agency of Amar Remedies, New Delhi. In this case, what had happened basically, successful resolution applicant took a stand that we are not able to implement the resolution plan because the status on the master data of the company is not changed. So this kind of stand cannot be taken. Status on master data of ROC was not changed, cannot be held back from bringing in the funds. You as an successful resolution applicant are expected to act on it. SRO cannot be heard to say that unless the ROC changes the status of company to active implementation of resolution. So implementation cannot be stopped. He cannot again run away out of this. When adjudicating authorities expressly refuse to grant a relief in this, they are successful resolution applicant and they have to act upon whatever they have committed. This cannot be a stand that ROC did not activate the company on the master data or its record.
However, my question is that how did it go into the category of under liquidation when during it's under CIRP? That's how the resolution plan is approved. How the ROC data showed as under liquidation?
No, it's not under liquidation. It is under CIRP, no?
No. What is mentioned here is status of the CIRP is under liquidation. That's the first line. You say second line. ROC, the status is changed under liquidation to active.
Yeah.
Under liquidation, how the change was made to under liquidation when CIRP is going on?
So this is just a summary, but I do have an order. We can dig in that order. Maybe I'll share that over email.
Yeah, sure. Thank you.
I'll share this order, ma'am.
Sure. Thank you very much.
Another case, Dhan Sagar Dealers Limited versus Anubrata Gangoli RP. Resolution plan cannot be approved without COC's approval, and again the resolution applicant who is unsuccessful has no locus, cannot question or challenge the approval of resolution plan. That is which has been held in this NCLT Kolkata bench. So unsuccessful resolution applicant cannot challenge about the successful resolution applicant, and plan cannot be modified without COC's approval unilaterally.
Madam, mute your voice.
Next judgment, Bank of India versus Vishal Ghesulal Jain. Now this case is regarding again 29A. what had happened in this case, a resolution plan was put to vote and it did not work out earlier. Again, a fresh resolution plan was put, and at that time, the second resolution plan was put. It is stated that the disqualification or eligibility of resolution applicant is required to be seen on the date of submission of fresh resolution plan, not the first one. That is what it has been held in this. Now, this is again a surprising case. A trademark was owned and resolution plan was approved without the trademark being considered into the resolution plan. It was held that later on it cannot be claimed, where a declaration of ownership of trademark after approved resolution plan, which is not part of the resolution plan, amount to modification. So such modifications again not allowed. Same judgment by Supreme Court that it freezes once a plan is approved, it becomes binding. No modification, no further modification allowed into it. Couple of last 2-3 judgments.
In this, I mean, how the trademark, since it is the property of the corporate debtor, separate claim, where separate claim is required, all the asset is automatically come to the RA.
Yeah, so it appears that the resolution professional has not collated that asset has not been considered into the records.
No, even though considered or not considered, I mean, asset, whatever the asset is of corporate debtor.
Yeah,
I mean, whether it is collated or not collated, later on in the future also, if someone finds that some asset is there, so he's very much there to claim those assets. This judgment seems, I mean, liability side is fine. That liability at that time is eroded, but how the asset is going to be eroded?
Achha. So the question is whether that amounts to modification of resolution plan or not.
I mean, modification is different thing. I'm saying the ownership. Even though it is not there in the plan, some asset which is traced later on,
ownership will continue.
Ownership will continue.
Yes.
See, he is taking control, sir. He is taking control of the CD. Whether the assets are visible today or invisible today, whatever he comes across at any point of time, the CD is asset.
It is the CD's asset.
It has nothing to do with the resolution plan. Whether it
plan,
is yes.
So what is the judgment it speaks about? I don't know. I mean, how this judgment?
Here, I think when we are drafting the resolution plan, at that time, one para needs to be added that whatever assets are mentioned or not mentioned also to be considered as a ownership of the SRA.
Okay.
Oh, it is. I mean,
but when he is in charge of CD, if the asset is in the name of CD,
exactly. He is the owner, irrespective of whether he mentioned in the resolution plan or not.
Exactly.
I mean, he is the owner of the asset. Later on, also he find out something, so he can claim that asset.
Yeah, he continues to be owner.
Yeah.
Yes. This is again a different kind of judgment. I discussed while discussing about the resolution plan. Ashok Dattatreya versus State Bank of India, whether extension of time for payment approved by resolution plan is a modification of resolution plan, whether NCLT has jurisdiction. Now, extension of time period. If you remember, we discussed this. I said, told this. Looks as surprising. Resolution plan contains some payment terms. And the question is whether NCLT or NCLT has a power to extension without concurrence of COC. It has been held that yes, NCLT has the power. Adjudicating authority has the power. The jurisdiction is there in adjudicating authority in appropriate cases. Granting extension of time in payment as per resolution plan for appropriate jurisdiction always vested with the resolution. So some kind of modification they allow.
In this, I mean, judiciary has power to make the modification to the extent of related to the timeline.
Yeah.
Without concurrence of the committee.
Correct. Kamlesh Mehta versus Miraj Ceramics Limited. When resolution plan for resolution applicant has not been approved and there is no other resolution plan. No, this is obvious judgment that no resolution plan was there. Although this is a fresh judgment, nothing new in this. No infirmity, no resolution plan was there available at that time. So liquidation was exercised. Order for liquidation was passed. Kalinga Allied Industries Limited, whether after having approved a resolution plan can seek directions. What happened in this case is after 2 years from the date of approval of resolution plan, a new resolution applicant was identified, which was giving a better deal. Again, it was held that no such modify or nothing such sort of is allowed. Again, the reference of 12A was given in this, that under the entire IBC withdrawal process of CRP is only 12A. Otherwise, there is no mechanism to do any further modification once the resolution plan is approved. Here, after 2 years of approval of first resolution plan, which is in the process of implementation, there they approached that we want a new resolution applicant who is better than the earlier. That cannot be done. That was not allowed. That could not be done. IBC Singapore case again. Here, SRA successful resolution applicant cannot withdraw on the grounds of lapse of more than 5 years. I think we also discussed this during discussion. The deterioration of financial status. So here also it was held that yes, he cannot withdraw because he has to exercise full due diligence, due care before the resolution plan. Last judgment for today. I do have few other judgments also on conditional resolution plan, but I'll share those over email. Like I said, some conditional resolution. There are few judgments wherein a resolution plan was approved with conditions. Conditional resolution plan were approved, and some of the cases conditional resolution plan was stated that modification is not allowed. Now, Lalit Kumar Jain versus Union of India, Supreme Court. Approval of resolution plan does not ipso facto discharge the personal guarantors. This is again a landmark judgment. Personal guarantors are not excluded. They are not excluded. Personal guarantors from their liability in the contract of guarantee. So that is what held in this judgment. Yes, so done with my presentation. I'll check whether anything else. So all these judgments I'll be forwarding to ma'am. Anything else? Maybe we have 5 minutes. We may discuss some additional points. We may. Oh, quickly, sir, I'll run through. We haven't seen the resolution plan template. Okay, I'll be sharing that template, no doubt about it. This is an NCLT order. Before that, I'll quickly run through this was a template, a format of resolution plan. I hope this is visible to all of you.
Yes.
Yeah. So these are the contents, basically index contents. Very small resolution plan. At the end, waivers are there. Again, preamble, interpretation.
130 page is not a small.
Sorry?
130 page is not a small.
Sir, no, not 130. It is 60, 70 pages. The other one we did was bigger.
In this your pagination above index pagination is 130 up to.
Okay.
Oh, sorry.
Okay. Okay. You can see here it's 69 pages, sir. Yes. So I'll share this template with you. It contains basically what is important here is the names of directors, the proposed directors. Which column is important is in my view this one, how much we propose to pay. What is there and what is the haircut and the percentage of it. Again, which is normally there in any of the NCLT order, we can see a tabular chart wherein what was the amount payable. So this table, key features of resolution plan summarized. How much we are have offered and how much we are paying to them. So that kind of stuff. And again, waivers, last part of it. Waiver is again a big topic. So yes, this is all about resolution plan. Anything, any suggestions? We have 3 minutes. Or we may conclude. if nothing is there.
Sir, can we discuss about when we are proposing for the haircut? So FC and OC, is there any formula can be planned so that successful resolution applicant can get the approval also, and at the same time he get maximum benefits?
Actually, very relevant, very valid question. You're talking about negotiation of resolution plan and
Absolutely.
negotiation of terms and conditions of the plan.
With respect to FC and OC, both things.
Yeah, FC and OC. I think all depends mainly upon the financial viability of the project and the financial conditions, what assets are available, what typically, even Pramod sir, you're also aware, what typically the promoters do is they identify what asset are there, what is the future possibility of working, they identify where the company went wrong, what is the valuation today, fair valuation, liquidation valuation is taken into consideration. Based upon that, they decide the value. And although the intention is not to do a haircut, but sometimes the financial position of the entity is such that, and again, the person who is putting into somewhere in the mind, practically, he has in mind that I am getting something or some asset or some benefit which is of at a lesser value, maybe something like that. And on the other hand, financial creditors or operational creditor, what they think is, okay, at least something is better than nothing. If you see the recent case of DS Kulkarni, on one hand, he is claiming that the valuation is 16,000 crore of the asset, and the resolution plan, which is approved in the order, it says that 824 crores. So banks like Bank of Maharashtra or these banks waiting for 7 years, they have taken a view that, okay, at least 10%. Over a period of 3 years, at least we are getting 10-15%. That is, so I think resolution plan drafting, submitting it, these negotiations is basically an evaluation matrix, a skillful job wherein a perfect balance has to be worked on between them. On one hand, resolution applicant, it should not be an endless, what we call as surprises. Acha, ye bhi hai kya? In one of the cases which it happened that nowhere he has considered, but suddenly the PCNTDA or the state authority which allots the land, like MIDC, so they came into picture, some old dues were there, they filed their claim. So these surprises keep on coming. So that's a balance between what we call as RP plays an important role. That's a balance between what a person tries to achieve and a perfect negotiation out of it. I think these factors are taken into consideration: the quantum, the value, the credibility, the possibility of. That's why I told resolution applicant at first stage only have to verify whether this is actually workable or not. Am I here for resolution plan or am I here to buy an asset? All these factors take into consideration. Having said that, there are also successful resolution plan which have worked very nicely. Professor, you can add something if you have some points, or any of you have some points.
No, you explained very well, sir. In fact, I have two more points. Sometimes, like if you, as you mentioned, the one case of the DSK. So many times in the CD, there are cases from the CBI, CID, ED, EOW, SFIO, everything is there. And as a resolution plan, SRA, sometimes some data is not available with the resolution applicant. So at the same time, if anything arises in future, like the PC and DTA case, so how to tackle this thing into the resolution application?
It's really difficult, but nowadays, a very recent, the 24th July resolution plan, which I talked about, in which I saw a line, I personally appreciate that, and that kind of adjustment can be, or thing can be done. That is, there was a mention of contingent liability. There was a mention of contingent liability. Of course, RP has to take a due care. We should be aware of all these things based upon the records. If every year we are paying the dues to the PCNTDA, or the land allotment has taken place, you can't simply ignore that. Definitely a provision of contingency has to be made in the resolution plan, and to that effect, the resolution applicant should be also, that mind should also be made. We also many a times advise that, suppose, say, giving an example, suppose 100 rupees is the capacity which we wish to deploy. Better quote 90 right now, because in future negotiation should be possible, and again there may be a contingency in future. So that provision should have to be made. That homework has to be done by RA, in my view, because surprises are there. There will be there. So yes, anything else, or shall we conclude?
Yeah, yours is a very good presentation. We went through and
Very nice, sir.
very
Very
nice.
nice.
Thank you very much.
Thank you.
Thank you very much, sir, for taking out time and addressing session on the topic designing effective resolution plan. The session was very interactive. Sir, you are requested to share the PPT with me so that I can share with the participants.
Thank you very much. Thank you. Thank you, everyone. A great learning experience for me also. Thank you.
Thank you, sir. Sir, please share the PPTs also.
Surely. I'll share the entire material over email. Thank you. Thank you very much. Thank you.
Thank you, sir.
Thank you, sir.
And now our next session will be at 3 p.m. There is lunch break of 1 hour. We will reassemble at 3.
Okay, thank you, madam.
Thank you.
3 o'clock.
Yes, ma'am.
Thank you.
Shall we start, Anjali?
Yes, ma'am, we should start now. Good
Okay.
afternoon, everyone. Can we
Yes.
start now?
Yeah.
Participants, can we start?
Yes.
Yeah,
Can
yeah,
start.
yeah. From my side, I'm okay. And all the participants, if they will on your videos, so this will be comfortable for me also. So
Now
I
the session will be taken by Sucheta ma'am as faculty on the topic recent important IBC case laws. Let me briefly introduce Sucheta ma'am. Ma'am is CS, IP and lawyer. She is currently associated as consultant with Adyo Legal Services law firm since 2016 and is in another firm of IP also. She is also having on CS peer reviewed firm named Sucheta Gupta and Associates. She has worked in areas such as IBC, SURFACI Act, trademark, company law, secretarial audit, listing compliance, legal drafting, FEMA, taxation, finance, accounts, and income tax. Now over to you, ma'am.
Yes. Welcome to all the participants and thank you to the ICSI IP Institute who has provided me the opportunity to speak on today's topic. I will share first the presentation before you, or I will also request to all the participants if they will on their video, then this will be more fruitful for me also. So I just share the presentation. So, my screen is visible.
Yes, yes.
Okay, thank you. Thank you. We'll start. First of all, the topic, the name you all are aware is the recent case laws of IBC. So, what is the motive of today's topic? Because you all read so many cases online, there are so many websites are also available to read these cases. So, what is the need of today's topic? So, because the need of today's topic is only that when we read the cases, some of the cases will be in our mind and some of them are slipped. And we have not remembered the cases for a long time. But if somebody has verbally briefed the case before us, then the case will be remembered to us for a long time. So this is the main motive of today's session, that I will make a brief of the recent cases before you. So you can remember the cases for a long time, and immediately you can put the case if there is any situation arise. Is there any petition you have filed? You can use these cases. So the main motto of today's topic is that I will make a verbal brief of the case, so the case can be remembered for a long time. So we'll start the topic. But before starting the topic, I will brief some of what is the Insolvency Act and how it will came into force. So it's a brief introduction of the IBC. So the prior to the IBC, you all are aware, you all are professionals here, who are attending the today's seminar. The prior to the IBC, there are so many legislative frameworks which was available, like the Companies Act, Sikh Industrial Companies Special Provisions Act, SURFACI Act, the Debt Recovery Bank, Recovery of Debt Due to Bank and Financial Institutions Act. So there are so many acts are available, still they are available, but the different petitions, application have been filed in these acts, and there is not a time-bound framework at that time. there is not a comprehensive and time-bound framework which can provide a resolution as per the IBC, insolvency and bankruptcy cases. So there was a need arise to take the IBC 2016 came into force in India, basically to provide the comprehensive and time-bound framework for resolving the insolvency and bankruptcy cases. So, what is the main objective of this IBC code 2016? The main objective is the consolidation of law. The whole are the available acts are there. We have filed separately the winding up petition. We have filed the other petition is the debt recovery tribunal. So there is a consolidated law has been introduced, which is the IBC. So this is a time-bound process, and you all are aware this is a creditor-driven process because the COC is the main committee which take all the decision in this process. So this is a creditor-driven process, and the maximization of assets value. By this process, the assets maximization also be possible, and promoting the entrepreneurship and the facilitating the easy exit. This is also providing like the voluntary liquidation, fast track process. So there are the so many process by which the easy exit is also available. Now, the history, the Lok Sabha, in Lok Sabha, this was passed on 5th May and in Rajya Sabha 11th May and come into force on 28th May 2016. All are aware about this. Or the early cases, the first case which was passed by the NCLT is the case of the Synergic Dure Automotive Limited, which was the order was came on 14th August 2017. This was the first case of the NCLT in which the order has been passed. And the first case of the Supreme Court was the Innovative Industries Limited versus ICICI Bank and ANR. This was the first case of the Innovative Industries. So let's start the recent important IBC case laws of NCLT. First, I will take up the cases of NCLT, and after that, we'll take up the cases of Supreme Court. So first, I have covered a case of NCLT, very recent judgment and very interesting. So Deepak Dayalal, ex-director of Messrs Pradeep India Impex Private Limited, and versus Messrs Steel Resource and Ramesh Kamath. This is the case name. So if we should remember the case, what will be the facts of the case? So first we should remember the name. Name is the Pradeep Impex India Private Limited. Who is the Pradeep Impex India Private Limited in this case? This is the corporate debtor. This is the corporate debtor. And Deepak Dayalal is the ex-director. He is the suspended director. And Messer Steel Resource is the operational creditor, and Mr. Ramesh Kamath is the resolution professional in this case. So what happened in this case? First of all, the Section 9 application was admitted by the NCLT. In this case, the NCLT admitted the Section 9 application. Can anybody tell me what is the Section 9 application?
Operational creditors.
Hello?
Operational creditors.
Yes, operational creditors. The volume is coming from somewhere. Hello? Can you hear me?
Yes, yes. Please go ahead, madam.
1 minute.
Yes,
Madam.
ma'am.
My screen is now is
Audible.
not visible. 1 minute. I just. I will join again. Actually, there is some network issue. I will join again. 1 minute. Hello. Can you hear me now? Hello.
Yes, we can hear you.
So, what is the Section 9 application? Is the who has filed this application?
Operational creditors.
Operational creditor. Yes, good. So the Section 9 application has been filed in this case, and this was filed by the Steel Resource. This is the corporate. This is the operational creditor who has filed this application, or against the corporate debtor. The name is the Priddeep Impex India Private Limited. So the Section 9 application filed against this company and agreed by the impugned order of the present appeal preferred by the suspended board of directors and seeking 41 delays. In this case, Mr. Deepak Dayalal is asking for the delay of 41 days required to be condoned in the appeal before the NCLAT. So he has filed this appeal before the NCLAT. All are understand the case now. What is the main purpose of filing this appeal is this? To condone the delay of 41 days. So you all are aware about the section in the IBC. How many days can be condoned by the court? Can anybody tell?
There's no time limit. It can be even 1,000 days we have got it condoned.
No.
30
10
days. 30
Yes.
days condonation. 30 days condonation is possible initially, and
yes.
in exceptional case 15 more.
Yes, so this is the case. The first 30 days, and if there is the sufficient cause involved, then the condonation is also allowed for 15 days, next 15 days. Now they are seeking 41 days delay in filing the appeal. So in this case, the ex-party order was passed by the NCLT. What happened? First, the ex-party order was passed by the NCLT. He has not availed. He is saying the council submit that the appellant had no knowledge of the proceedings. The council of the appellant has been submitted this. The appellant became aware of the proceedings only when the IRP informed the appellant on 6/12/2023. So he is saying the order was passed. We are not aware of this order, and we have come into the knowledge only this date, 6/12/2023, about the impugned order through email. It is the case of the appellant that an appeal can be filed by an aggrieved person only when he becomes aware of the order. So he has taken this ground. The appeal can be filed only when the aggrieved person become aware of the order. So he was become aware on 6/12/2023 as per their submission. Now, further, what another ground he has taken now? The further it was submitted that sometimes needs to be excluded while calculating the limitation period. So they had also submitted that sometimes of required to be excluded as per the ground of limitation. So in the present case, explaining further, it was pointed out that the appellant tribunal was having winter Christmas holiday from 23/12/2023. So what was the date of the order? First, you say the order was pronounced on 22/11/2023, means 22 November 2023. The order has been passed. Now, and the IRP informed the appellant on 6/12/2023. And he is saying there was some holidays because in November the order was passed, but Christmas holidays and winter holidays will started from 23 3/12/2023 till 1/1/2023. So the holiday period is 9 days. They are saying the holidays period is 9 days and need to be excluded. And this period required to be excluded. Basis this calculation, the period of 30 days for filing the appeal would have expired on 13/1/2024. If we will count that order has been passed on 22/11/2023. So the first 30 days has been expired already on 23/12/2023, and next 15 days is also expired by this date. So they have submitted the period of 30 days for filing the appeal would have been expired on 13/1/2023 as per their opinion, that the 30 days period will be expired on 13/1/2024, yani 13 January, which date being the Saturday and a not working day, followed by the Sunday being yet another holiday. The last date for the purpose of filing the appeal would be the 15/1/2024. They have also submitted the 13 is also not the last date to filing the appeal, because this was the Sunday. So the next working day is the 15/1/2024. So they can submit on this date. It was further submitted that during this period, a close cousin of appellant has passed away. They have third submission is that the cousin of the appellant has also passed away, which necessitated his presence for a related rituals for 13 days. So the 13 days is also required to them. The first, they have said there are the Christmas holidays or some holidays, and after that they have submitted there is the cousin is also expired. So the next 30 days is also required. So what happened? The order was pronounced on 22/11/2023 and take the contention that the appellant was not aware of the order. First contention he has already taken that he has not aware of the order because the order was passed the ex parte order. The date on which the order is pronounced is to be excluded from the calculation of the limitation in terms of section 12(1) of the Limitation Act. So the 30 days period comes to end on, as you count, 22. After 30 days, if you will count, this will be expired on 22/12/2023. And further 15 days will come to end on 7/1/2024. So these two dates on which the 30 days is also expired and the next 15 days is also expired. Now the appeal filed on, he has filed on appeal on 1st February 2024. It means it's a huge delay. 7 months is already gone. 22/12 already gone. Now they have filed the appeal on 1st February 2024. Means the order has been passed on November, December, January, February. Means 3 months. In total, if we will count, there are the 3 months involved in this. And after this period, they have filed this appeal on 1st February 2024. The appeal filed after a delay of more than 15 days is allowed for further condonation. So the NCLT, what was held by the NCLT in this case, it is clear that NCLT registry had sent the impugned order by email. As you are all are aware, if any order has been passed by the registry, so the order copy is also be served to the applicant as well as the respondent on their registered email ID. And obviously the NCLT registry has take up the email ID from the ROC portal or whatever has been submitted by the appellant. So the order copy is already served to them by the email. Therefore, it becomes all the more questionable on the part of the appellant to raise the plea that he was not aware of the impugned order. So it cannot be said by the appellant the NCLT held that it cannot be said by the appellant that he was not aware of the order, because already a copy of the order has been served through the email to them. So first ground which he has taken is dismissed by the NCLT. Now the second ground. The another ground taken for the delay is that due to the Christmas vacation, the tribunal was closed and hence the appellant was restrained from filing the appeal, the second ground. This explanation is lack of merit because registry is open and this is operational for 24/7 hours, because we can file the e-filing, we can make the e-filing. We all are aware, we can make the first, we will make the e-filing and then we will clear the scrutiny from the NCLT. So how can the appellant take this ground? There was the Christmas vacation. So the appeal, what happened? The conclusion is that the appeal having been filed on 1st February 2024, the appeal was clearly being filed a delay of more than 15 days from the date of expiry of the limitation. So our jurisdiction to condone the delay is limited to only 15 days as per section 61 subsection 2 of the IBC. Hence, the delay of condonation application cannot be entertained and dismiss the appeal. So in this case, the NCLT have dismissed the appeal because the delay is cannot be condoned. They have taken so many grounds, but all are dismissed by the NCLT. So what we have done from this case today, we have learned that whenever there is a due date to filing any appeal or any application, we should aware that the e-portal is working. So we should file the appeal online. First of all, the scrutiny will take time. So this is not the error on our parts. This will be the error on the part of the registry. So we should file the application first online within the time limit, within the time period, whatever the provided as per the act. So the first case is or every can any hello. Everybody can understand the first case. Is there confusion in this case?
Madam, I think there is one more contention can be taken by the appellant that to file the appeal.
Yeah, but this is also this ground also not entertained by the tribunal, because the 13 days, if we will say ki there is a sufficient cause, so we can take the 15 days time is already given. So why you have not filed? Because this event was happened after the 15 days which was already crossed on 7/1/2024, because the death was happened only 13/1/2024.
No, here my suggestion, my thought process is that
Yeah.
generally for filing of any appeal,
Yeah.
Appellant authority is expecting that the appellant should bring the certified true copy, and for the getting the certified true copy, approximately 1 week can be considered. So that way his 13 days gap could have been fulfilled if he has taken the clear that they applied for the certified true copy and they got after 1 week or 2 weeks. So problem could have solved.
Yes, sir. We can first.
No, I think no such ground is allowed by an
I will also brief a case on certified true copy also today. I will also brief a case on this topic also.
Yes.
The 15 days delay, 15 days, the sufficient cause which was given in the act, which is only for there is a in this case this event was happened, which you have seen the 30 days he has asked again for the death of the cousin, which was happened only 13/1/2024, after the period of 13/1/2024, and the period of 15 days is already expired on 7/1/2024. So why he has not filed this application till this date? So we should file the application within the time, as because the registry is always open, is 24/7, as the e-filing is available. So we have learned from this case now. Now the second case is also very interesting case. Regional Provident Fund Commissioner, EPFO Regional Office Jamshedpur versus Mamta Vinani Company Appeal is 30th March 2024. The order has been passed by the NCLT. So what happened in this case? CIRP against the corporate debtor. Is the corporate debtor in this case is the RD Rubber Reclaim Limited is the corporate debtor here. The appellant regional PF commissioner submitted its claim on 28/8/2020 for this amount, and section 7A claim for this amount, and 7Q is for this amount. These are the claims which have been submitted in different sections on these dates. So what is 7A? First of all, we should know what is the section 7A. The section 7A is the determination of money due from the employers. This is the section. And 7Q, what is section 7Q? Is the interest payable by the employer. And what is section 14B? Is the damages of the Employee Provident Fund and Miscellaneous Provision Act 1952. So these are the provisions related to the Employee Provident Fund Act 1952, and three sections are there. The 7A is providing for the determination of money, 7Q is providing for the interest payable, and 14B is providing for the damages. So these three sections are there. So what happened in the case? The resolution professional admitted the entire amount claimed under section 7A, 7Q, and the 14B. So he has admitted, resolution professional already admitted in this case these all the amounts as per these sections. But the resolution plan has been approved by order dated this, and the resolution and under the resolution plan, the amount proposed to be paid to the appellant is only this. In this, the resolution plan has been approved in this case, and the resolution plan, in the resolution plan, the amount is proposed to be paid only this, which was claimed under section 7A. So the determination of money due from the employer, only this amount was admitted in the resolution plan is and they have proposed to pay for this amount. With regard to the amount claimed under section 7Q and 14B, there is no payment was proposed in this case. So what happened? The resolution professional refuting the submission of the counsel for the appellant submits that the appellant has filed this appeal only on 21/2/2022, because the resolution plan is already passed in this case 21, and appeal was filed on 21/2/2022 against the order dated this. More than 9 months have been passed from the date of the order by which the resolution plan was approved by the NCLT. So the successful resolution applicant, SRA, also submits that the entire amount under the plan has already been distributed. He has submitted this. The claim under section 14B took the view that the central board is empowered to waive. He has further submitted that the central board is empowered to waive the damages under section 14B as per the scheme of under the Employee Provident Fund Act 1952. So what happened in this case? The NCLT held that we are of the view the SRA along with the order of this tribunal may pray to the central board if they are submitting. The central board have already having some scheme by which the damages can be cannot be take up. So the court has ordered to go to the central board and file the appeal there file the SRA, the NCLT giving the direction to the SRA to, we are of the view that the SRA along with the order of the tribunal may pray to the central board to waive off the 100% damages. And now coming to another part of the claim which was admitted in CIRP, the amount is the 7Q amounting this. 7Q is related to the can anybody tell me 7A, 7Q, 14B? 3 sections we have discussed here. What is 7Q?
Interest.
Yes. So interest. So the for the interest amount, they have directed the amount under section 7Q amounting to rupees this. We are of the view that the said amount is required to be paid by the SRA to the appellant. Yani, after passing the resolution plan and 9 months has already gone, but still the SRA, the liability has been put up on the SRA to pay this amount by this order. So we should remember whenever we have submit any resolution plan, that there is any demands of the any authorities. So what is the amount of?
Madam.
Yeah. Yes, sir.
This order is challengeable because how an NCLT can entertain 9 months this thing.
But
because
sir,
they don't have power. Supreme Court had clearly given judgment that
so many
NCLT do
judgments
not have
are
anything.
there. Yes, I know, sir. So many judgments are there, and section 32 is also there. That the after passing the approval of resolution plan, SRA is not applicable for is not liable for any liability. But in this case, what happened? You see, the resolution professional admitted the entire amount of the claim under section 7A, 7Q, and 14B. In this in this case, the entire amount already admitted by the RP, because this is not a new case, new sections which was the authority has submitted after the the approval of the resolution plan, because the claim was already admitted by the RP.
Madam, I agree, but only this maximum interest and principal part, that is under the excluded state, liquidation state. But this damage is not under.
So the damages
it is admitted
for
by
the
RP. That's why it
damages,
will simply go to.
For the damages, he has not
Damage
the NCLT not directed to pay this amount. NCLT said that you go to the CBDT central board and pray there to waive off the 100% damages.
No, but
because the scheme is available.
Here in this case, the damage should be treated as normal government dues. Whatever the treatment being given to the normal government due, only as per that, if he doesn't propose, then also it is fine, because it is normal government due. It is not the priority payment.
Yes. So, I'm saying if there is any resolution plan we have incorporated and we have submitted, we should consider that earlier if we have admitted any amount like damages, like interest. So this will be is there any amount proposed for these sections in our resolution plan or not? We should also check as a RP. We should also check if we have admitted the entire amount, then the proposal by the SRE has been submitted for this amount or not submitted, because after 9 months the problem has been arised. Okay, sir.
It's fine, ma'am. This resolution plan should address in a manner that for damage, etc., 1% should be allocated. 1% only, not full amount.
Yes,
so treatment is done.
Yes,
because it is normal government due.
So the NCLT not given any direction on the damages. He has already only given the direction for the amount of interest only. Okay. So now the third case is the Vishal Sethi versus Messrs College Group Infrastructure Private Limited. What happened in this NCLT case? This is also This is also one of the interesting case. The appellant is the operational creditor, was appointed as the general manager. Appellant is the general manager of the corporate debtor. The name of the company is Messrs. College Group Infrastructure Private Limited. This is the name of the company, and Vishal Sethi is the appellant. So is the general manager. The appellant submitted his resignation on 26/1/2016. In this case, the appellant have submitted his resignation on 26/1/2016 on the behest of the corporate debtor and sent an email to the corporate debtor. He was appointed as a GM on 10/10/2014. Please remember the date. 10/10/2014, he has appointed as a GM, but he has submitted his resignation on 26/1/2016. Okay. Now, on the behest of the corporate debtor and send an email to the corporate debtor on the same date indicating the balance of his arrears salary and the requested the corporate debtor to pay the same as soon as possible. He has sent the email to the corporate debtor now. Following this email, a full and final settlement was provided by the corporate debtor, admitting an outstanding amount of rupees this, because he has filed, first he was filed the application before the NCLT in section 9, and at that time, there was a settlement arise between the corporate debtor and the applicant, and and the corporate debtor admitted his outstanding amount of this and the debt due and payable or this. A settlement arrived between the corporate debtor and the applicant under section 9, application withdrawn. So the application was withdrawn because he has admitted the outstanding. Now, what happened? Now a breach caused in settlement by CD. Now matter was reopened before the NCLT. Again, the matter was reopened before the NCLT. Now because he has not made any payment to him, so now the NCLT rejected the application by holding that the applicant is working with the separate entity. On the first stage, the application has been withdrawn, and in the second stage, NCLT rejected the application. Why? Because he has said that he is working with another entity, the separate entity, not with the corporate debtor. So the appellant worked with the corporate debtor, that is from October 2024 to March 2015. At this period, salary regularly paid to him. Means October 2014 to 15, March 15. These months' salary was regularly paid to him. Now, thereafter, the appellant transferred to M&T is the another entity. He has transferred to another entity is the M&T. Subsequently, when the appellant got transferred to M&T, there remained no privity of contract between the appellant and the corporate debtor. Now there is no agreement between the appellant and the M&T. Is the corporate debtor, sorry, because he has transferred in the M&T, which is another entity. So there is an existence of dispute. So NCLT not admitted section 9 petition because there is a dispute. So NCLT is not admitted this petition. It is also submitted. Both are controlled by the same management. He has also submitted that both are controlled by the same management, but still the petition was not admitted. What happened in this case? The NCLT held that the settlement deed to which the appellant has adverted attention to had been correctly noticed by the adjudicating authority to have been signed between the appellant and the M&T, not with the corporate debtor. Now the settlement deed was agreed between the appellant and the M&T, not with the corporate debtor. So the corporate debtor was not obligated to honor the terms of the settlement deed, which was signed between the appellant and some entity other than the corporate debtor. Because you all are aware, in fact, there is a subsidiary company also exist of the corporate debtor. This will always considered as the separate entity as per the point of view of the IBC. So the court has told that the settlement deed has been signed between the appellant and the MNT, not with the corporate debtor. And the corporate debtor was not obliged to honor the terms of the settlement deed, which was signed between the appellant and the some entity other than the corporate debtor. Empathetically ascertaining that the doctrine of privity of contract is a settled principle of law, under which the third party cannot be made liable under contract unless he is a party to the said contract, because the corporate debtor is not the party in the contract, in this contract, so he cannot be made as a party in this contract. And applying this principle, the corporate debtor was not liable to any manner to discharge the liability of a different legal entity. Appellant was not its employee, and therefore no dues were payable by the corporate debtor to the appellant. So the adjudicating authority in the impugned order, after noticing the full and final settlement documents, was observed and same was executed between the appellant and MNT, not between the appellant and the corporate debtor. The appellant rendered services to MNT, which was a separate company from the corporate debtor. We are satisfied that the adjudicating authority did not commit any error in rejecting the Section 9 application. We find no reason to disagree with the findings of the adjudicating authority. There is no merit in the appeal. So what we have done in this case, if we are the employee in any case and there is any transfer has been made by the company, so we should check what is the terms of the contract and who will make the payment and to whom we should initiate the proceeding. So this is the case. Now, the fourth case is the Slimline Realty Private Limited versus Mr. Jigar Bhatt Company. So 3 cases we have discussed. Anybody remember the name of the case? The earlier 3 cases which we have discussed. Any case in three of them. Can anybody tell? Remember the case name? Anybody remember the case name which I have briefed today?
It was Jamshedpur case, rubber matter.
No, three of them. What I have explained today, only from them.
Today you have explained the PF versus this rubber. Mamta Biyani was the this thing.
Which case? Which name is?
PF department.
PF department. Yes, one of them is there. Yeah, and another is, anybody remember the case name?
Al Sethi.
Yeah.
Vishal Sethi.
Yes, Vishal Shetty. Yes, sir. So, so now you see the power of verbal explanation. Now, if somebody briefed the case, Vishal Shetty, we have explained. Regional Provident Fund Commissioner, I have explained, and another is the Prithvi Impex India Private Limited. So I think all 3 cases briefs everybody will remember, and the case name also be remembered. Now we'll start the 4th case. Is a Slimline Realty Private Limited versus Mr. Jigar Bhatt Company appeal. So this was decided on 31st May 2024. What happened in this case? The Reliance Marine and Offshore Limited, this is the corporate debtor, was admitted to CIRP. Wide order dated this. It is 21/8/2019. Thereafter, the order of liquidation was also passed in this case, 6/12/2021. So the liquidation was passed in 21 and the CIRP was passed in 2019. So after 2 years, we can see the liquidation order has been passed in this case. So the corporate debtor has no business, no physical assets or any employee. ना इसके पास there is no business, no physical assets, no employee. The only assets of the corporate debtor is the subscription in the non-convertible unsecured bonds of the 5 private limited companies. So he is having only what is the unsecured bonds of 5 private limited companies. The bond was subscribed in year 2013 and the due for redemption on 25/7/2019. This was due for redemption. So the liquidator respondent in this case issue a demand notice to the appellants. The Slimline is the appellant you have seen. So what happened? The liquidator name is the Jigar Bhatt. He has issued the demand notice to the appellant in these 5 companies: Slimline, Avocado, Budding, Mercantile, Replenish, and the Winsome Realty Private Limited. These are the 5 companies to make the payment with respect to the non-convertible unsecured bond subscribed by the corporate debtor. Now, the SEC did not accede to the request of the liquidator for initiating the proceeding against the appellant companies. The liquidator, however, on SEC, you know what is the SEC meaning here? Can anybody tell? Yeah? What is SEC here?
Stakeholder consultation.
Yes.
Meeting.
So the stakeholder consultation committee did not accede to the request of the liquidator for initiating the proceeding against the appellant companies. The liquidator, however, on 30/9/2023 filed the application against the appellant under section 7. Yani section 7, everybody aware what is section 7? Section 7. Can anybody tell?
Financial.
Yes.
Action
Yes.
Financial creditors.
Yes. So the section 7 for initiating the application against the financial creditor. So the liquidator filed the proceeding as per section 7 against these companies, claiming default of the financial debt. He has considered this is the financial debt, the bond is the financial debt, and he has filed the application. Now, the liquidator filed an application praying for ex post facto approval for section 7 application with the various relief. Ab ex post facto approval. What is the ex post facto approval in this case? I will also brief you. The adjudicating authority by order dated this 7/2/2024. Yani recently in February 2024 allowed the IA and granted the ex post facto approval to the liquidator to continue and proceed with the company petition filed by the liquidator against the appellants. Agreed by the order this granting ex post facto approval to the liquidator, the appeal has been filed. Why he has filed this appeal? Slimline, Realty Private Limited and other companies, why they have filed this appeal? Because of the ex post facto approval granted by the adjudicating authority to the liquidator. Now, what is the ex post facto approval? Meaning, to describe something that influence event in the past, like the ex post facto pay arise, which reimburse you for the work you have done already. It means. So, the work has already been done, but now the pay arise for this work. It means we can say is the retrospective effects also can say. So on submission of the learned counsel for the parties, following issue has been arised for consideration in these appeals. First, what question has arisen? Whether the statutory requirement under section 33 subsection 5. What is section 33 subsection 5 proviso? Can anybody read this section? Is anybody having the act with him or her? Section 33 subsection 5 proviso. Is there anybody having this? Having the book of IBC? Can read this proviso? Nobody. So I will read this. What is the section 33, subsection 5 proviso? Whenever we will take the classes, we should keep all the things together with us. So what says this section proviso, subsection 5 proviso, provided that a suit or other legal proceeding may be instituted by the liquidator on behalf of the corporator with the prior approval of the adjudicating authority. This proviso provides to obtain the prior approval of the adjudicating authority by the liquidator for instituting any suit or proceeding on behalf of the corporate debtor is mandatory requirement or a directory requirement. This is a mandatory proviso or this is the directory requirement of this proviso. So first question have been arised in this case. The second question is, what are the consequences and status of the proceedings instituted by the liquidator on behalf of the corporate debtor without prior approval of the adjudicating authority? So what consequence will arise if the liquidator has been instituted the suit on behalf of the corporate debtor without the prior approval of the NCLT? And whether the post facto approval granted by the adjudicating authority of a proceeding instituted by the liquidator without obtaining the prior approval shall make the proceeding authorized and competent, and whether before the approval under section 33 subsection 5 to the liquidator to institute proceeding on behalf of the corporate debtor, the party against whom the proceeding are to be instituted has to be given an opportunity, and whether the impugned order this passed by the adjudicating authority is unsustainable or deserve to be set aside. So these 5 questions have been arised in this appeal. So first answer, the question got the is the section 33 subsection 5 is mandatory proviso or the directory? So the question is to answer is as to, this was held by the NCLT. The question is to be answered is as to whether the requirement of prior approval of adjudicating authority for instituting a suit or proceeding by the liquidator is a mandatory requirement or a directory requirement. The learned counsel for the parties have relied on various judgments of Honorable Supreme Court and the Tribunal on statutory interpretation which need to be briefly noticed. Section 33(5) uses a negative impression and contain an injunction that no suit or legal proceeding shall be instituted by or against the corporate debtor when the liquidation order has been passed. As you all are aware about this section 33 subsection 5, which provides we cannot file any suit or injunction or legal proceeding against the corporate debtor when the liquidation order has been passed. But the legislative intentment of the provision is clear that no suit or proceeding be instituted by or against the corporate debtor to protect the liquidation estate. It means this provision has been provided for the protection of the liquidation assets of the corporate debtor. Further, the institution of proceeding by the corporate debtor has also prohibited. Why prohibited? To save the liquidation estate from the unnecessary expenses, because there are the unnecessary expenses will be involved. So, for instituting any case or proceeding, so for providing, for prohibiting and saving the estate of the the corporate debtor, the provision has been provided in the Act. There is an exception to the above injunction, but the section has been provided in the Act. No suit can be filed by or against the corporate debtor, but the proviso is also provided in this section, which provides that there is an exception to the above injunction. The legal proceeding may be instituted by the liquidator on behalf of the corporate debtor with the prior approval of the adjudicating authority. So if we want to file any suit or proceeding against the third party, if the company is in at the stage of the liquidation, we have required first the approval from the adjudicating authority. Then we can file any suit. So the proviso is an exception to the main provision of section 33 subsection 5. The requirement of the prior approval by the adjudicating authority for instituting any suit or proceeding is mandatory and cannot be held as a directive. So this proviso is mandatory and we cannot say this is the directive. What is the mandatory is required to comply compulsory, and directory is have the discretion. So this is the mandatory, not the direct. First answer is clear now. Now the second question, what is this? What are the consequences and status of the proceeding instituted by the liquidator on behalf of the corporate debtor without the prior approval of the adjudicating authority? What consequences? So he has also submitted a Supreme Court judgment. Is the Vanshidhar Shankarlal versus Mohammed Ibrahim case, where the considering sections 171 of the Companies Act, in this case it was considered, and has laid down that the proceedings are initiated without the leave of the court, the proceeding shall be unauthorized. If we institute any suit or proceeding without the leave of the court, then this will be unauthorized. However, it will become competent from the date when the leave is granted. So above judgment thus clearly says that the institution of proceedings shall not be void or nullity when it has been filed without the leave of the court. First, we are not having the leave of the court. After that, ex post facto effect has been given by the court. So this is permitted. Now, the question number 3 is there also. Whether a post facto approval granted by the adjudicating authority for proceeding institution of the liquidator without obtaining prior approval shall make the proceeding authorized or competent. So the answer is that post facto approval granted by the adjudicating authority with regard to the continuation of the proceeding already instituted by the liquidator, which was instituted without obtaining prior approval, shall make the proceeding authorized and competent from the date when the post facto, ex post facto approval has been granted. Now, question is 4. What is the question is there also? Whether before approval under section 33 subsection 5 to the liquidator to institute proceeding on behalf of the corporate debtor, the party against whom the proceeding are to be instituted has to be given an opportunity. We have required to serve the application before instituting any proceeding to them. This is compulsory or not? So what held by the court, the scheme delineated under section 33 subsection 5 does not indicate that the liquidator has to give any opportunity or notice to the party against whom the approval is sought to initiate the proceeding, not required. So we have not required to take any or to give any opportunity or to serve the petition before filing the proceeding before against the party. So the 5th question is there. Whether the impugned order dated this, which was passed by the adjudicating authority, is unsustainable or deserve to be set aside. So what held? In the view of the foregoing discussion, we do not find any ground to interfere with the order of the adjudicating authority dated this, and all the appeals are dismissed. So this was decided on 31st May 2024. All the questions have been answered by the NCLT, and the section is the mandatory. We have learned today section 33 subsection 5 proviso for taking the approval prior instituting the suit against the third party. The approval from the adjudicating authority is the mandatory provision, not a directory provision, and we have not required to serve or give the opportunity to the appellant before instituting any proceeding against him. So, and the post facto approval, if any granted by the NCLT by the court, then this will become authorized. So all questions has been answered here, and we have learned that this is a mandatory and not a directory provision, and all this, all other things also. So everybody have cleared this judgment. Is there any doubt about the judgment, or everybody have cleared? All are listening me or not? Hello? Am I? Hello? Am I
Yes, ma'am,
audible?
you are audible.
Okay, okay. So everybody have cleared this judgment?
Yes, ma'am.
Okay, okay. So for these 5 questions has been answered in this judgment, and very clear 33 subsection 5 proviso is that mandatory, not a direct. Now, come to the 5th case. This is the State Bank of India versus India Power Corporation Limited case.
Madam, can you please put it in the presentation mode? There's
Yeah.
something at the left side. You please close that and put it in presentation mode so that it's clear. It's too
1
small.
minute. It's now it is clear. I have closed this.
Yes, better, but it's very small. If you can.
Okay, okay. I will also try to make it more wider. 1 minute. Just.
You have to go to full screen.
Yes, yes. Is this clear now?
It's not full screen. Actually, it
Yes,
can come. It
this
can
is
occupy the full screen.
Ma'am, this is full screen, ma'am.
75%.
This is full screen.
Okay.
Now, is this clear?
Yeah, better, better.
Oh. So, what happened in this case? The 5th case is the State Bank of India versus India Power Corporation Limited case. The appeal arises in response to the questions referred to the answer because of the dissenting opinion of the bench of the 2 members. This is the certified copy related case. What happened in this case? The 2 members bench of NCLT having the different view. Means 1 member having the other view and the 1 member is having the another view. So the 3rd member take the decision on this appeal. So what happened in this case? As to how the aspecting pertaining to the certified copy should be construed for the purpose of filing the appeal under section 61 of IBC code 2016. Rule 22. What is certified copy? There was because there is a dispute between the certified copy and free copy. You all are aware. First copy which have been served by the NCLT free of cost, and this is free copy, and the another copy is the certified copy which we have made some demand from the NCLT. We have submitted the postal order there and some amount of fees, and they, as per the pages, 10 rupees per page basis, I think they have provided the certified copy. So what was the issue? Is the certified copy related issue in this case. The Rule 22 of the NCLT Rule 2016 are extracted here under. What is provided in Rules 22 of NCLT Rule? This is provided presentation of appeal. Every appeal shall be presented in form NCLT 1 form required in triplicate copy chahiye by the appellant or the petitioner or the appellant or the respondent, as the case may be, in person or by his duly authorized representative duly appointed in this behalf in the prescribed form with the stipulated fee at the filing counter, and non-compliance of this may constitute a valid ground to refuse to entertain the same. So they have required this file, triplicate, and also a certified copy. So after that, we can file. Every appeal shall be presented in this form and at the filing counter, and non-compliance of any of this may constitute a valid ground to refuse and entertain the same. Now, every appeal, this is the first section, subsection 1, rule sub rule 1. Now the sub rule 2, what is saying? Every appeal shall be accompanied by the certified copy of the impugned order. Yani ki first rule is saying in this form, and the second sub rule is saying with the along with the certified copy of the impugned order. Now the word certified copy has not been defined under the NCLT rule of 2016. Now, this is not defined. So, rather the word, the certified copy has been defined under NCLT rule 2016, which read as under. In NCLT rule, the meaning of certified copy is not defined, but this is defined to some extent in NCLT rule. Now, what is saying NCLT rule? Section 2(9). Certified means in relation to the copy of the document as thereunder is the certified as provided in section 76 of the Indian Evidence Act, certified as provided as per section 6 of the Information Technology Act 2000. So these two sub-rule provided what is the certified copy meaning as per the NCLT rule. Rule 50 of the NCLT rule does not speak that it's the provision which required that there have to be the demand on payment of a fee. Rather, Rule 50 is an obligation which is casted on the registry to send a final order to the parties free of cost. First, the registry will send a copy to us if we are the parties to the case as a free of cost copy, and further obligates that the certified copy may be made available with cost as per the schedule of the fee in all other cases. So the certified copy may be made available with the cost as per the schedule of the fees is also provided in this. Thus, here too, the concept of the free copy is different concept than the certified copy made available on cost. Free copy is different concept and the certified copy is a different concept here. The act of filing an application for a certified copy is not just a technical requirement for computation of limitation, but also an indication of the diligence of the aggrieved party in pursuing the litigation in a timely fashion. So, court has cleared this, that filing of application for a certified copy is not a just technical requirement for the computation of limited, but also a indication of the diligence of the aggrieved party in pursuing the litigation in a timely fashion. So now, what happened? The answer, because of the dissenting opinion of the two bench, as this was arised. So what Rule 50 of NCLT Rule 2016 provides that registry shall send a certified copy of final order passed to the parties concerned free of cost, and certified copy may be made available with the cost as per the schedule of the fees in all other cases. Now, as we have already read, the certified copy meaning is as per the section 76 of Evidence Act or 6 of the Information Technology Act. So I have defined section 7 of the 76 of the Indian Evidence Act provides that every public officer having the custody of a public document which every person has the right to inspect shall give that person on demand a copy of the payment of legal fees thereof together with the certificate written at the foot of such copy, that it is a true copy of such document or part thereof as the case may be, and such certificate shall be dated and subscribed by such officer with his name and his official title, and shall be sealed whenever such official authorized by law to make use of the seal, and such copies so certified shall be called the certified copy. So this is the section 76 of the Evidence Act provides. Now, what held by the NCLT, the third member, holding thereof the free copy provided under Rules 50 of NCLT Rule 2016 cannot be treated as certified copy, because certified copy is the copy which we will demand from the registry, and for this we have required to make some payment for this. So these copies can also only be treated as the certified copy. So the certified copy referred to under rule this, and the free copy will not satisfy to be a certified copy as defined under section 2J of the NCLT rule to be read with section this. So this was cleared by the NCLT that the free of cost copy cannot be considered as a certified true copy. So certified, whenever we have filed any appeal, we should consider that we have a certified copy of the order, or we have a free copy of the order. If we have the free copy of the order, because if the time is going on, suppose this period is not be excluded by the NCLAT. So first, what should be the practical approach for filing the appeal is there. We should file whatever the order we have available at the time, because the time limit will be expired if this will expired or this not be condoned by the court. So the case can be dismissed. So we should file first whatever the copy we have, we are having, and after that we can make an application before the NCLAT. This is the certified copy, and we have taken this time 1 month or 2 months to taking from the registry. So initially we have filed the appeal with the order, with this order, but subsequently we will file the certified copy. So is the case is clear to everyone now? What is the certified copy and what is the free of cost copy which we have received from the registry? Can anybody, hello, can anybody hear me? So the case is clear to everyone?
Yes, madam, please proceed.
Okay, thank you. अगर आप लोग थोड़ा सा मुझे बोलते रहते हो कि हाँ, मुझे लगता है कि आप लोग सब सुन रहे हो मुझे.
Madam, instead of reading word by word, line by line, if you can brief the case based on your understanding of the order, if you are able to brief, it will be helpful for us.
No. I'm trying to brief as per my understanding only, because the brief which have been made here, this is as per my understanding. So my motive is also there कि I can let you know what is the sections provides. So there is a required to show the sections also. The section has been provided this, so you can remember these sections also. So the motto is also there. So I will try anybody.
Madam, we are all practicing in this area. So what we are interested in knowing is what is the case law and what is the issue and the order of the tribunal. Further, if you want to use it, we have to go through this order in detail, look at the section and all that. So this is my suggestion, you know.
Okay. I will keep your suggestion with me and try to explain more fruitfully to you, to all the participants. So the case is clear. What is the certified copy? What is the difference between the certified copy and the free copy? The registry which has been provided to us, this is the copy which is free of cost copy, and the copy which we have demand from the registry is the certified copy. Now the next case, the Sikkim Power Investment Corporation Limited versus Mr. Umesh Garg. So this is the sixth case. Umesh Garg is the resolution professional in this case. So what happened in this case? There was a company, is the holding company of the corporate debtor. The name of the company is the Athena Energy Ventures Private Limited. So this is the holding company of the corporate debtor. And what happened in this case? A development and implementation of hydroelectric power project has been granted by the Arunachal Pradesh, in this case, to this company. And the Athena Denway Power Limited. There are two companies, Athena Energy Ventures Private Limited. This is the holding company, and Athena Denway Power Limited. This is the corporate debtor. So there are the two different entities. One is the holding and one is the corporate debtor. In this case, was incorporated. The Athena Denway Power Limited was incorporated for a special purpose vehicle to implement the project on failure of the corporate debtor in the repayment of the facility. So this was incorporated for the special project, but there was a failure on the part of the corporate debtor in the repayment of the facilities. What facilities he has taken? When on the application filed by the Indian bank, he has taken the financial facilities from the Indian bank. So the Indian bank has been filed the Section 7 petition against this company, and the adjudicating authority have passed the order in 2017 for CI.